Transfer of Property Act. Frequently asked questions on Transfer of Property Act. Q. 1. State briefly the history of Transfer of Property Act 1882. What changes were brought by Amending Act of 1929? What are the objects of the Act? Ans. Historical background. Before passing of Transfer of Property Act 1882, there was no specific codified law relating immovable properties. There was state of uncertainty in courts in presidency towns, as far as administration of justice on the subject. Similar was the situation in other parts of India. Courts were deciding the matters primarily on principles of equity, justice and good conscience. In the absence of any legislative enactments, a confusion started arising because of conflicting decisions of court on any point. Because of such chaotic situation, strong necessity of codified law on the subject was felt. In order to remove such confusion, a law commission was appointed in England to prepare a substantive law of transfer of properties in India. The draft bill as prepared by Law Commission was widely criticized because of many diversities and anomalies. Bill was revised and republished but again received criticism, and it was pointed that bill should be confined to its application on transfer of properties by act of parties and should not contain unnecessary matters, and ultimately draft bill was again given back to Third Law Commission, consisting of Sir Charles Turner and other eminent jurists. Finally, the bill was passed on the 17th of February 1882. After passing of Transfer of Property Act 1882, situation had improved little because of conflicting opinion of different high courts on many provisions of Act. Act was required to be amended to remove state of confusion on the subject. Since the passing of Transfer of Property Act 1882, it was amended on 12 occasions. Provisions of Act were primarily based on decisions of Chancery courts and courts of common law in England. So in order to remove drawbacks, Act was thoroughly revised and a bill was drafted by Legislative Department of India in 1926, and in 1927 a special committee was appointed to examine the provisions of Act for its amendment. Committee suggested various important changes in Act, and ultimately Transfer of Property Amendment Act 20 of 1929 was passed, which brought following important changes. 1. Doctrine of part performance was given statutory recognition and embodied in Section 53A. 2. Legal proposition of backcourtless pendants was clarified even more. 3. Section 63A recognized the right of mortgagee to compensation for the money spent by him by bringing improvement in hypotheca. 4. The law of merger in relation to mortgages has been simplified. 5. Registration of compulsorily registerable document operators considerable notice. 6. Mortgagee has to bring single suit in consolidation of all mortgagees held by him in respect of which mortgage money has become due and in respect of which he has right to obtain same kind of decree. 7. Section 65A has defined the mortgagee's right to lease the property and has provided statutory criteria for judging the validity of such leases. Objects. The following have been the objects of the Transfer of Property Act. 1. One of the objects of the Act was to render the system of transfer of immovable property a system of public transfer. Registration is therefore generally insisted upon for completing a transfer except in cases of transactions of small value. 2. Another object of the Act was to render more simple and efficient the law relating to mortgages. Section 60 of the Act recognizes the mortgagee's right to redeem, and his right has not been made subject to a contract to the contrary. Full effect being thus given to the equitable maxim, once a mortgage always a mortgage. 3. Another and even more important object of Act was to bring the rules which regulate the transmission of property between living persons into harmony with the rules affecting its disposition by testaments, and thus to provide the necessary complement to the Indian Succession Act. With this view, the rules of the Succession Act as to contingent and conditional bequest have been applied mutatis mutandis to transfers inter vivos. Most of the provisions of the Act were based on the decisions of the courts of equity in England before 1881, which had largely been followed by the Indian courts. Scope of the Act. The scope of the Act is limited to transfer of property between parties inter vivos, i.e. living persons by their own acts, as distinguished from a transfer by operation of law, as in case of insolvency, or perfection of sale in execution of a decree. The Act has no application to disposal of property by will. It also does not deal with the case of succession. The scope and main objects of the Act shall be clear from the following words. First, to bring the rules which regulate the transmission of property between living persons into harmony with the rules affecting its devolution upon death, and thus to furnish the complement of the work commenced in framing the law of intestate and testamentary succession. And secondly, to complete the code of law of contract, so far as relates to immovable property. In aiming at these objects, the legislature has striven to avoid technicalities and refinements, to discard all rules whereby the parties to a transaction were made liable to unexpected consequences, and provisions indeed which were found in practice to lead to embarrassment and litigation. Like the Contract Act, it is not and does not purport to be an exhaustive measure. Thus, Act covers transfer by act of parties inter vivos. The preamble of the Act lays down that, whereas it is expedient to define and amend certain parts of the law relating to the transfer of property by act of parties, it is hereby enacted as follows. Q. To define and explain following. A. Immovable property. B. Actionable claim. Uns. A. Immovable property. Section 3 of Transfer of Property Act defines immovable property as immovable property does not include standing timber, growing crops or grass. So definition of immovable property, U.S. 3 of the Act does not clearly and positively indicate the real nature of the term. According to Section 3(26) of General Clause Act, immovable property shall include land benefits to arise out of land and things attached to earth or permanently fastened to anything attached to the earth. So definition of the term immovable property, as given in General Clause Act 1897, is also not comprehensive. However, after having read the definitions of the term as given in both the above said acts, term may be said to include the following: A. Land. B. Benefits to arise out of land. C. Things attached to the earth, except standing timber, growing crops and grass. Land. Land means determinate portion of Earth's surface, e.g. lake, mountains etc., and objects beneath the surface like mines etc., or all other objects placed by human agency on or under the surface with intention of permanent annexation, so as to become part of the land. Benefits to arise out of land. Apart from the property being immovable from the physical point of view, very benefit arising out of it and every interest in such property is also regarded as immovable property. A debt secured by a mortgage of immovable property is an interest arising out of land and is thus regarded as immovable property. Similarly, right to receive future rent, right to take minerals, right collect lac from jungle, fish from pond are examples of benefits arising out of land. Things attached to earth. Things attached to earth includes 1. Thing rooted in the earth. 2. Things embedded in the earth. 3. Things attached to what is so embedded in. 4. Chattels attaches to earth or building. Things rooted in the earth includes all the trees or shrubs, but except standing timber, growing crop or gross. Standing timber, growing crop or gross, these are movable properties. Trees which bear fruits are not standing timber but are considered as a movable property. There are however certain trees, lime, mango gives fruits as well as timber. Whether they are movable or immovable property depends upon circumstances of case. It also depends upon intention to use them as timber, movable, or fruits, immovable. Where the intention is to cut them for the purpose of utilizing wood, they would be regarded as movable property. Things embedded in the earth includes all the building and other constructions. Things embedded in earth includes all windows. Doors in a house are attached to the house for the permanent beneficial enjoyment, which includes electric ceiling fan. Whether fan is a movable property or not depends upon the intention of fixation. If it is permanent beneficial enjoyment of property, then it is a movable property. Chattels attached or fixed to building are a movable property. Following properties are judicially recognized as immovable properties. 1. Right to collect rent of immovable property. 2. Right to collect ferry. 3. A right of way, light, fishery. 4. Debt secured by mortgage. 5. Hereditary offices of worship. 6. Equity on redemption. 7. Right to collect lac from trees. Following properties are not immovable properties. 1. Right of worship, a royalty, a payment made to the writer of a book by publisher. 2. A decree for arrears of rent. 3. Right to recover maintenance. 4. Machinery which is not permanently attached to the earth. 5. Government promissory notes. 6. Standing timber, growing crop, gross. B. Actionable claim. Section 3 of TP Act defines actionable claim. Formally, any claim which could be recognized by the courts affording grounds for relief was an actionable claim. Now the term in restricted to claim to debts and to claims to any beneficial interest in movable property not in possession either actual or constructive of the claimant. A debt secured by a mortgage is excluded from the category of actionable claim. Section 3 defines the term as follows. Actionable claim means 1. A claim to any debt other than a debt secured by mortgage of a movable property or by hypothecation or pledge of movable property. Or 2. To any beneficial interest in movable property not in the possession, either actual or constructive, of the claimant which the civil courts recognize as affording grounds for relief. Whether such debt or beneficial interest be existent, accruing, conditional or contingent. Actionable claim therefore means 1. A claim to any debt, other than a mortgage debt, and 2. A claim to any beneficiary interest in movable property. 1. A owes 1,000 rupees to B. B's claim is an actionable claim. 2. A promise to deliver 100 bags of rice on a certain day. He fails to deliver on the day promised. B has a right to sue for damages, but B's claim for damages is not an actionable claim. 3. Claim for arrears of rent is actionable claim. 4. A claim to rent to fall due in future is an actionable claim for it is an accruing debt within the meaning of the definition. 5. A share in partnership is an actionable claim. The expression, beneficial interest in movable property, includes the right to claim the benefit of a contract for the purchase of goods. Q. 3. What is meant by attestation? What are the requisites of a valid attestation? Point out legal effect of attestation. Uns. Attestation. Attestation means witnessing of execution of deeds such as will, mortgage, gift or sale etc. In attestation it is necessary to prove that the executant of deeds signed it in presence of attesting witnesses and witnesses signed the deed in presence of the executant. In Kumar Harish Chandra Singh Dio vs Bansidhar Mahanti and others, Air 1965 South Carolina 1738. It was observed that the object of the attestation is to protect the executant from being required to execute a document by the other party thereto by force, fraud or undue influence. Similarly was held in Dhiren Baling vs Must. Bhutuki and others, Air 1972 Guwahati 44. It was also observed that attestation and execution are two different acts, one following the other. The former is to ensure that executant was free agent and not under pressure nor subject to fraud when executing the document. In order to constitute valid attestation, the essential conditions are: I. There must be two attesting witness. 2. Each of them must have seen the executant sign or fix his mark to the instrument and 3. Each of the two attesting witness must have signed the instrument in the presence of the executant. In M.L. Abdul Jabbar Sahib vs. H. Venkat Sastry, 1969 South Carolina 1147, it was observed by Supreme Court that to attest is to hear witness to a fact. For attestation it is essential that witness should have put his signature, animo attestendi, that is for the purpose of attesting that he has seen the executant sign or has received from him a personal acknowledgement of his signature. If a person puts his signature on the document for some other purpose, for example to clarify that he is a scribe or identifier or a registering officer, he is not an attesting witness. In Section 3 of the TP Act, attested, in relation to an instrument, means and shall be deemed always to have meant attested by two or more witnesses, each of whom has seen the executant sign or affix his mark to the instrument, or has seen some other person sign the instrument in the presence and by the direction on the executant, or has received from the executant a personal acknowledgement of his signature or mark, or of the signature of such other person, and each of whom has signed the instrument in the presence of the executant. But it shall not be necessary that more than one of such witnesses shall have been present at the same time, and no form of attestation shall be necessary. Legal effect of attestation. Legal effect of attestation is that the document which requires attestation is valid only when it is properly attested, and valid and proper attestation is proved. However, mere attestation of a document does not show that the attestator had notice of its contents. Attestation stops the person putting his witness from denying the execution. However, there may be circumstances attending the attestation, such as that the contents were read over to the attestator, and in that case he may be stopped from challenging the right of the transferee of denying the authority of the executant to execute the document. It becomes binding on him also. Q. 4. Define and explain the term notice. Uns. Section 3 of Transfer of Property Act defines the term notice as a person is said to have notice of a fact when he actually knows that fact, or when, but for willful abstention from an inquiry or search which he ought to have made, or gross negligence, he would have known it. Explanation I. Where any transaction relating to a movable property is required by law to be and has been effected by a registered instrument, any person acquiring such property or any part of, or share or interest in, such property shall be deemed to have notice of such instrument as from the date of registration, or, where the property is not all situated in one subdistrict, or where the registered instrument has been registered under subsection 2 of Section 30 of the Indian Registration Act, 1908, 16 of 1908. From the earliest date on which any memorandum of such registered instrument has been filed by any sub-registrar within whose subdistrict any part of the property which is being acquired, or of the property wherein a share or interest is being acquired, is situated. Provided that 1. The instrument has been registered and its registration completed in the manner prescribed by the Indian Registration Act, 1908, 16 of 1908, and the rules made thereunder. 2. The instrument or memorandum has been duly entered or filed, as the case may be, in books kept under Section 51 of that Act, and 3. The particulars regarding the transaction to which the instrument relates have been correctly entered in the indexes kept under Section 55 of that Act. Explanation 2. Any person acquiring any immovable property or any share or interest in any such property shall be deemed to have notice of the title, if any, of any person who is for the time being in actual possession thereof. Explanation 3. A person shall be deemed to have had notice of any fact if his agent acquires notice thereof whilst acting on his behalf in the course of business to which that fact is material. Provided that if the agent fraudulently conceals the fact, the principal shall not be charged with notice thereof as against any person who was a party to or otherwise cognizant of the fraud. So from the definition it is clear that notice may be actual or construction, according to circumstances. It was observed that the definition in Section 3 includes both an actual and constructive notice. Legal presumption of knowledge of notice arises from a. Willful abstention from inquiry or search, b. Gross negligence, c. Omission to search registration in register kept under Registration Act, d. Actual possession and a. Notice to agent, 1998 All. LJ. 1288, 1295. Actual and express notice. An actual notice is one by which one gets direct and express knowledge of a fact. Actual notice must be definite information given by a person interested in thing in respect of which the notice is issued. Actual notice cannot be established by proof of casual conversation. Constructive notice. Construction notice of fact is one which a person is presumed, in law, to have received the knowledge of that fact. Constructive notice is knowledge which the courts impute to a party upon a presumption so strong that it cannot be allowed to be rebutted that the knowledge must have been communicated. The question of constructive notice is question of fact which falls to be determined on evidence and circumstances of each case. In Muralidhar Bhapuji Valve vs. Yalpa, Chogal, Air 1994 Bohm. 358 Defendant failed to make necessary inquiry in respect of possession of suit land by going to the site or from neighboring landowners. It was held that constructive notice of suit agreement shall have to be imputed to defendant in view of actual possession of the suit land being with the plaintiffs. Presumption as contemplated in constructive notice can be taken. 1. In relation to a fact. I. When but for willful abstention from an inquiry which a person ought to have made, he would have known the fact, or e. When but for gross negligence B would have known it. 2. In relation to document compulsorily registerable. 3. In relation to actual possession. 4. In relation to a notice to an agent. Q. 5. What do you mean by transfer of property? State what properties are capable of transfer and which cannot be transferred under Transfer of Property Act. Ans. Transfer of property. Section 5 of Transfer of Property Act lays down as transfer of property means an act by which a living person conveys property, in present or in future, to one or more living persons or to himself and one or more other living persons, and to transfer property is to perform such act. So, transfer of property is a process whereby property is made over by one living person or persons to other living person or persons and for that purpose to perform such act. Section 5 makes it clear that Act deals with only transfer inter vivos, i.e. transfer between living persons. In Kempraj vs. Buston Son and Company. Air 1970 South Carolina 1872, Supreme Court observed that essence of word, transfer, is backward to convey, and therefore a transfer of property would include not only the 5 specific categories of transfer dealt within the Act, namely sale, mortgage, lease, gift and exchange, but any transaction which has the effect of backward conveying any property or any interest therein from one living person to another. In Sunil Siddharthbhai vs. Commissioner of Income Tax, Ahmedabad, Gujarat. Air 1986 South Carolina 368, 372, it was observed by Supreme Court that it is not necessary that transfer should be of entire bundle of rights from transferor to transferee. Transfer may consist of one of the estate only out of all estates comprising the totality of rights of owner into a joint or shared interest with other person. An exclusive interest is a larger interest than share in property. To the extent exclusive interest is reduced, there is transfer. The word backward property, as used in Section 5 of Act, may be used in the objective sense of a concrete thing which is the subject of ownership or other rights, or it may be used in the sense of the rights and the interests of the owner or other person in the property. It is in the latter sense that the term backward property is used in the Act. A transfer of property may take place in present or in future, that is to say the actual conveyance of the property may take place in present or in future. But the property itself must be in existence as the property of the transferor. On the other hand, a transfer of property not in existence operates only as a contract to be performed in the future as soon as the property comes into existence, and such a contract can be specifically enforced if the transferor fails to transfer the property to the transferee after the property comes into existence. A transfer presupposes two distinct persons, i.e. transferor and the transferee, and thus there can be transfer by one to himself, but that is possible when the person exercise dual personality, e.g. as an individual and as a partner in a firm or a company, when there is a contract between A and the firm or a company. Section 6 of Transfer of Property Act provides as to which properties are capable of transfer. Section 6 says, property of any bind may be transferred, except as otherwise provided by this Act or by any other law for the time being in force. A. The chance of an heir apparent succeeding to an estate, the chance of a relation obtaining a legacy on the death of kinsman, or any other mere possibility of a like nature, cannot be transferred. B. A mere right of re-entry for breach of a condition subsequent cannot be transferred to anyone except the owner of the property affected thereby. C. An easement cannot be transferred apart from the dominant heritage. D. All interest in property restricted in its enjoyment to the owner personally cannot be transferred by him. D. A right to future maintenance, in whatsoever manner arising, secured or determined, cannot be transferred. A mere right to sue cannot be transferred. F. A public office cannot be transferred, nor can the salary of a public officer, whether before or after it has become payable. G. Stipends allowed to military, naval, Air Force and civil pensioners of the government and political pensions cannot be transferred. H. No transfer can be made, 1. Insofar as it is opposed to the nature of the interest affected thereby. Or, 2. For an unlawful object or consideration within the meaning of Section 23 of the Indian Contract Act, 1872, 9 of 1872, or, 3. To a person legally disqualified to be transferee. I. Nothing in this section shall be deemed to authorize a tenant having an untransferable right of occupancy, the farmer of an estate in respect of which default has been made in paying revenue, or the lessee of an estate, under the management of a court of wards, to assign his interest as such tenant, farmer or lessee. So the rights and properties as described in clause A to I are exceptions to general rule and cannot be transferred. Transferability of property is general rule, its non-transferability, an exception, and burden of proof that particular property is not transferable lies on person alleging it. Q. 6. What are the criteria to determine a family arrangement? What is the object of a family arrangement? Is it required to be registered? Discuss. Ans. Family arrangement in Kale vs. Deputy Director of Consolidation. Air 1976, South Carolina 807, Supreme Court, while explaining about family arrangement, has observed that term family has to be understood in a wider sense so as to include within its fold not only close relations or legal heirs but even those persons who may have some sort of antecedent title, a semblance of a claim, or even if they have a spare succession, is so that future disputes are sealed forever and family, instead of fighting claims inter se and wasting time, money and energy on such fruitless and futile litigations, is able to devote its attention to more constructive work. Supreme Court further observed, even if one of the parties to settlement has no title under the arrangement, the other party relinquishes all its claim or titles in favor of such person and acknowledges him to be the sole owner. Then the antecedent title must be assumed and family arrangement will be upheld. In Ramcharan Das vs. Girja Nandini Devi, Air 1966, South Carolina 323, Supreme Court observed that, to effect family arrangement, all that is necessary is that the parties must be related to one another in some way and have a possible claim to property or a claim or even a semblance of a claim on some ground as say, affection, registration and family arrangement. In A.C. Lakshmipathy and others vs. A.M. Chakarpani Redder, Air 2001 Mad. 135, it was observed by Madras High Court that a family arrangement can be made orally. If made orally, there being no document, no question of registration arises. If the family arrangement is reduced to writing and it purports to create, declare, assign, limit or extinguish any right, title or interest of any immovable property, it must be properly stamped and duly registered as per the Stamp Act and Registration Act. Whether the terms have been reduced to the form of a document is a question of fact in each case to be determined upon a consideration of the nature of phraseology of the writing and the circumstances in which and the purpose with which it was written. However, a document in the nature of a memorandum, evidencing a family arrangement already entered into and has been prepared is a record of what had been agreed upon. In order that there are no hazy notions in future, it need not be stamped or registered. Only when the parties reduce the family arrangement in writing with the purpose of using that writing as proof of what they had arranged then. Where the arrangement is brought about by the document as such that the document would require registration as it is when that it would be a document of title declaring for future what rights in what properties the parties possess. If the family arrangement is stamped but not registered, it can be looked into for collateral purposes. Whether the purpose is a collateral purpose, is a question of fact depends upon acts and circumstances of each case. A person cannot claim a right or title to a property under the said document, which is being looked into only for collateral purposes. A family arrangement which is not stamped and not registered cannot be looked into for any purpose in view of the specific bar in Section 35 of the Stamp Act. Similarly in Kale vs. D.Y. Director of Consolidation, Supreme Court observed. In Tech Bahadur Bhujil vs. Debbie Singh Bheel. Air 1966 South Carolina 292 It was pointed out by this court that a family arrangement could be arrived at even orally and registration would be required only if it was reduced into writing. It was also that a document which was no more than a memorandum of what had been agreed to did not require registration. So it is only when the parties reduce the family arrangement in writing with the purpose of using that writing as proof of what they had arranged and where arrangement is brought about by the document as such that the document would require registration as it is then that it would be a document of title declaring for future what rights in what properties the parties possess. Q. 7. Who are the persons competent to transfer? Ans. Section 7 of Transfer of Property Act says, every person competent to contract and entitled to transferable property or authorized to dispose of transferable property not his own is competent to transfer such property either wholly or in part and either absolutely or conditionally, in the circumstances, to the extent and in the manner allowed and prescribed by any laws for the time being in force. In Balai Chandra Mandal vs. Indu Rekha Devi, Air 1973 South Carolina 782. It was observed that a person's conduct in collecting rents and managing an estate of the landlord does not empower him to transfer the land as the landlord's agent. Section 7 of the Act, however, does not deal with the question as to who can be transferee of property. Section 6(b) provides that no transfer can be made to a person legally disqualified to be transferee. According to that provision, a minor is not disqualified to be transferee although a contract with a minor is void. As it was held in a decision reported in Air 1936 Pat. 153 that there is nothing in Section 7 to prevent a person not competent to contract from being transferee of property. So this means if a minor enter into contract through guardian or next friend, he can be purchaser or mortgagee, otherwise not. Q8. A transfer of property passes to transferee all the interest which the transferor is capable of passing. Explain. Ans. Section 8 of Transfer of Property Act lays down the general rule of transfer of property. Section 8 says about operation of transfer and lays down, unless a different intention is expressed or necessarily implied, a transfer of property passes forthwith to the transferee all the interest which the transferor is then capable of passing in the property and in the legal incidents thereof. Such incidents include, when the property is land, the easements annexed thereto, the rents and profits thereof accruing after the transfer, and all things attached to the earth. And, where the property is machinery attached to the earth, the movable parts thereof. And, where the property is a house, the easements annexed thereto, the rent thereof accruing after the transfer, and the locks, keys, bars, doors, windows, and all other things provided for permanent use therewith. And, where the property is a debt or other actionable claim, the securities therefore, except where they are also for other debts or claims not transferred to the transferee, but not arrears of interest accrued before the transfer. And, where the property is money or other property yielding income, the interest or income thereof accruing after the transfer takes effect. So as held in Vishwanath vs. Ramraj, Air 1991 All. 193 that there may be presumption that when land is transferred, all things attached to the earth such as tree and shrubs are also transferred along with the land in view of provisions of Section 8R, W Section 3 of TP Act. However, there can be no presumption in case of vice versa. So court in certain cases construe the deed of transfer to determine the extent of interest transferred thereby under such deed, and in view of provisions of Section 8, court can, in the absence of clear and expressed intentions of parties to deed as to what is and what is not transferred under a deed, hold that transferor intended to transfer all the incidents attached to the property to the transferee. The object of Section 8 is to stabilize title and to remove from the region of pure speculation what passed in the mind of transferor of the transferee at the date of transfer. Similarly in Air 1940 Pat. 516 it was observed that the object of section is to clarify what are the legal incidents of each particular class of property which passes along with the property when it is transferred, and not to lay down any rule as to what words are necessary to effect a transfer of any particular kind of property. As per Section 8 of the Act, following are the necessary incidents attached to different property and ordinarily passes from transferor to transferee in the absence of clear intention of parties to the contrary. Property. Legal incidents. 1. Of land, easements, rents and profits and all things attached to the earth. 2. Of house, easements, the rent accruing after the transfer, locks, keys, bars, doors and other things provided for permanent use. 3. Of machinery attached to the earth, movable parts of the machinery. 4. Of debt, securities, right to resort to some property for the satisfaction of the debt. 5. Of money or other property yielding income. Interest or income accruing after the transfer takes effect. As a matter of construction, the grant of land must be taken to be not only of the land but also of everything beneath or with the land. Prima facie the owner of a surface of the land is entitled ex jus to everything beneath the land and in the absence of any reservation, in the grant. The minerals necessarily pass with the rights to the surface. The golden rule of construction is to ascertain the intention of the parties to the instrument after considering all the words in their ordinary and natural sense. To ascertain this intention, the court has to consider a. The relevant portion of the document as a whole, and b. The circumstances under which the particular words were used, and c. The status and the intention of the parties using the words. Where it is stated in the deed of settlement that the widow conveyed the property which passed to her through a will executed by her husband and the will was invalid as executed by a Hindu who had a son living at the time. It was held by the High Court of Andhra Pradesh in the case of Koding Venkat Subbe vs. Abburi Ranjaya, Air 1972 Andhra Pra. 246, that it cannot be argued that she conveyed also her interest in the property as heir of the son. It is seen from the recitals that the intention was not to transfer all the interest whatever she was capable of passing but only the interest which she acquired under the will of her husband. Section 8 of the Transfer of Property Act starts with the words, "unless a different intention is expressed or necessarily implied," and so the section does not apply so to operate as a transfer of all her interest, including the rights acquired as the heir of the deceased son. Q. 9 describe the rule against inalienability. Uns. Section 10 of Transfer of Property Act lays down the rule that any transfer of property, term of which absolutely restrain the transferee for further alienation of property is void. This is also termed as rule against alienability. Section 10 says, where property is transferred subject to a condition of limitation absolutely restraining the transferee or any person claiming under him from parting with or disposing of his interest in property, the condition or limitation is void, except in the case of a lease where the condition is for the benefit of the lessor or those claiming under him. Provided that property may be transferred to or for the benefit of a woman, not bring a Hindu, Mohammedan, or Buddhist, so that she shall not have power during her marriage to transfer or charge the same or her beneficial interest therein. According to Section 10 of the Act, it is permissible to make a transfer subject to conditions, but such conditions must not contravene the provisions of the Act and the transfer takes effect as if no such condition had been attached to the transfer. On the other hand, there are certain conditions which, if imposed, render the transfer itself void. Section 10 is one of the group of sections which deals with void condition of the former type. This section lays down that where property is transferred subject to a condition absolutely restraining the transferee from parting with his interest in the property, the condition is void. Suppose A transfers his property to B with the condition that B shall not sell it. This condition is void and B takes the property absolutely and he may sell or not as he pleases. The principle underlying the Section 10 of the Act is that a right of transfer is incidental to and inseparable from the beneficial ownership of property. The rule in the section that condition of absolute restraint of alienation is void is founded on the principle of public policy allowing free circulation and disposition of property. In Air 1986 Cur. 56 it was observed that to improve a total restraint on transfer of property or to impose rules which keep it out of circulation forever offends public policy. Irrespective of whether such conditions are imposed by deed of transfer, a will or a simple contract. An absolute restraint is one that takes away the power of alienation completely or substantially, e.g. a condition on the transferee that he shall not alienate property, except for religious purposes. Partial restraint is one that imposes some restriction on the power of alienation but the transferee is substantially free to alienate property in a wide variety of ways, e.g. a condition that transferee cannot transfer the property for any religious purpose. Thus, if power of alienation is restricted to a particular person, only then it is void as an absolute restraint. If the power of alienation is exercisable in favor of a class of persons, it would be construed as a partial restraint. In PVS Venkataschalam vs. PVS Kabalumurthy Pillai, Air 1955 Mad. 350 it was held that Section 10 does not prohibit a partial restraint on the disposition of property but renders an absolute restraint void, in deciding the question whether the condition or limitation restraining the disposition of property is absolute or partial. The court has to look at the substance and not so much to form of condition or limitation. Exceptions to Section 10 lease. When the condition is for the benefit of the lessor, it will be valid. The lessor can always restrict his lessee's liberty of alienation. The logical reason for this exception is that a landlord should be free to choose the person who shall be in possession of his land. Thus, a condition in a lease, that the lessee shall not sublet or assign, otherwise the lessor may re-enter, is valid. Married woman. The second exception is for the benefit of a married woman, not being a Hindu, Muslim or Buddhist, so that she shall have no power, during her marriage, to transfer or charge the property. Thus a condition restraining alienation may be imposed when the property is transferred to a married woman. Q. 10 describe the rule against "repugnant conditions." An exception to this rule. Uns. When a person makes an absolute transfer, he cannot at the same time impose upon his transferee any condition whereby he is restrained in his enjoyment or disposition of property. A full ownership of property confers upon its owner complete liberty of action with regard to its enjoyment and disposition etc. If any condition or limitation is imposed upon such liberty, that condition would be repugnant under Section 11 of the TP Act. Section 11 of the Act says that where on a transfer of property, an interest therein is created absolutely in favor of any person, but the terms of the transfer direct that such interest shall be applied or enjoyed by him in a particular manner, he shall be entitled to receive and dispose of such interest as if there were no such direction. The principle is plain enough. When a property is transferred absolutely, it must be transferred with all its legal incidents. The vendor is not competent to sever from the right of property incidents which the law inseparably annexed to it and thereby to abrogate the law by private arrangement. A condition postponing enjoyment beyond the minority of the donee is void for repugnancy. Where a testator directed that his son was not to enjoy the property bequeathed to him till 4 years after his death, the son attained majority before the father died. It was held that the son took an immediate absolute interest, and so the restraint on enjoyment was to be regarded as invalid. 1. A makes an absolute gift of a house to B with the direction that B shall reside in it. The gift is absolute and the direction is void. B may live in the house or not as he pleases. 2. A makes a gift of a house to B on condition that the gift will be forfeited if B does not reside in it. The condition is valid, for the gift is not an absolute gift but it is a gift subject to a condition of a defeasance, or of revocation. 3. A sold farm to B with the condition that B pays 4,000 rupees per year so long as B is in enjoyment of the property. The condition is void and B is not bound to pay 4,000 rupees to A per year. Leelavati vs. Firm Ramdhari, Hair 1971 P&H 87. Exception. Exception to the general rule that restriction on the enjoyment of an absolute interest cannot be imposed is equally important. If the transferor is the owner of another piece of immovable property also, he may for the benefit of that property impose a restriction on the enjoyment of the property transferred by him. Section 11 relates on the enforcements of the restrictions against the transferee, where Section 42 refers to the enforcement of the restriction against purchases from the transferee. Q. 11 explain the rule against perpetuity. What are the exceptions to rule against perpetuity? Does the rule apply to a covenant for preemption? Ans. Rule against perpetuity, Section 14 of the Transfer of Property Act, 1882, provided for the rule as follows. Section 14 Rule against perpetuity. No transfer of property can operate to create an interest which is to take effect after the lifetime of one or more persons living at date of such transfer, and the minority of some persons who shall be in existence at the expiration of that period, and to whom, if he attains full age, the interest created is to belong. The policy of the law has been to prevent property from being tied up forever. There are two ways in which the property may be tied up or rendered inalienable, viz., either by imposing a condition absolutely restraining the transferee from parting with, or disposing of, his interest in the property, or by creating a succession of partial future interests in favor of the unborn persons, and so postponing to a remote period the time when the property will vest in somebody absolutely. Section 10 of the Act strikes the first method by invalidating conditions against alienation. This section restrains the power of creating future interests by providing in the rule against perpetuities that such interest must arise within certain limits. The rule of perpetuity looks to the date at which the contingent interest will vest, if they vest at all, and holds them to be void as a perpetuity if this date is too remote. Though invariably called the rule against perpetuities, a better name would be the rule against remoteness of vesting. The modern rule against perpetuity is that no contingent or executory interest in property can be validly created unless it must necessarily vest within the maximum period in one or more lives in being and 21 years afterwards. It is this modern rule which with certain modifications has been adopted in Section 14 of the TP Act. So long as the transferees are living persons, any number of successive estates can be created. A transfer may be made to A for life and then to B for life and then to C for life and so on, provided A, B and C are all living persons at the date of transfer. But if the ultimate beneficiary is someone not in existence at the date of the transfer, Section 13 requires that the whole residue of the estate should be transferred to him. If he is not born before the termination of the last prior estate, the transfer to him falls under Section 14. If he is born before the termination of the last prior estate, he takes a vested interest at birth. The rule against perpetuity, however, does not require that the vesting shall take place at the birth of the ultimate beneficiary. What it does require is that the vesting cannot be delayed in any case beyond his minority. Analysis of the rule. 1. The vesting of estate cannot be postponed beyond the lifetime of any one or more persons living at the date of the transfer. For example, if an estate is given to a living person, A for life, then to a living person B for life, and then to the unborn son of B, the son of B must be in existence on or before the date of the expiry of the life estate in favor of B. It means that except in minority there must be no interval between the termination of the previous interest of a living person and the vesting of the interest in the person who was not in existence at the date of the transfer. 2. The vesting of absolute interest in favor of an unborn person may be postponed until he attains full age. For example, an estate may be transferred to A living person, and after his death to his unborn son when he attains the age of 18. Such a transfer would not be violative of the rule against perpetuity. Exceptions to the rule against perpetuity. There are following exceptions to the rule against perpetuity. 1. The Act relaxes the rules against perpetuity in respect of transfers of property for the benefit of the public or for the advancement of religion or knowledge or for any other object beneficial to mankind, and the vesting of such transfer inter vivos may be delayed beyond the period of perpetuity. 2. Personal agreements, i.e. agreements which do not create any interest in property, do not offend the rule against perpetuities. For instance, the Shibate of a temple agree to appoint the family of C as pujaris from generation to generation to perform the services of the temple and make provisions for the expense and remuneration of the office. The agreement is valid and is not hit by the rule against perpetuity. 3. The third exception is provisions for payment of debts of the transferor. A direction that the income of the property shall be accumulated for payment of debts does not tie up the property absolutely, because the person indebted can discharge the debt at any time. 4. The fourth exception is that covenants of redemption in a mortgage do not offend the rule. An agreement for preemption gives a first opinion to purchase land. Since an agreement for the purchase of lands does not create any interest in the property, the rule against perpetuities does not apply to an agreement for preemption. This has been held also by full bench of the Allahabad High Court in Aulad Ali vs. Khans 49 All. 527 FB. Q. 12. What is the effect of invalid prior disposition or ulterior disposition? Ans. Section 16 of Transfer of Property Act says, where, by reason of any of the rules contained in Section 13 and 14, an interest created for the benefit of a person or of a class of persons fails in regard to such person or the whole of such class. Any interest created in the same transaction and intended to take effect or upon failure of such prior interest also fails. The rule embodied in this section is a rule of English law that a limitation following upon a limitation void for remoteness is itself void, even though it may not itself transgress the rule against perpetuity. Thus, if a gift is made to his grandson, and then to B, the first gift is void, so subsequent gift to B failed. So where an interest is intended to take effect after a prior interest and prior interest is void for any reason, the subsequent interest also fails. In Girijesh Dutt vs. Datta Din 1934-147, IC 991, A made a gift of her properties to B, who was her nephew's daughter. The gift by A was made for the life of B and then to B's male descendants absolutely if she should have any. But if she, B, had no male descendants, then to B's daughter without power of alienation, and if there was no descendants of B, male or female, then to her, A's, nephew. B died without having any issue. It was held that the gift in favor of unborn daughters was invalid under Section 13 because the gift was of a limited interest and subject to the prior interest in favor of B. The gift in favor of the nephew also fails under Section 16, which provides that if in a transfer of property the prior interest fails, the subsequent interest also fails. Q. 13. Describe the rule against accumulation. Or, how long can the income of any property transferred be directed to be accumulated so as to prevent its being received and enjoyed by the transferee? In what cases accumulations can be validly be directed? Ans. Rule against accumulation. Section 17 relates to the rule against accumulation and provides how long the income of any property transferred can be directed to be accumulated so as to prevent its being received and enjoyed by the transferee. The section permits accumulation during the following periods. 1. The life of the transferor, or 2. A period of 18 years from the date of the transfer, whichever is longer. Illustration. A transfers property to B in 1920 with a direction for accumulation for 30 years. A dies in 1940. The direction will be valid till 1940 and void thereafter. If, however, the transferor dies in 1930, the direction will be valid till 1938, 18 years from the date of transfer, and void thereafter. Exceptions. The section recognizes 3 exceptions to the rule against accumulation. 1. Payment of debts. A direction for accumulation for the purposes of the payment of the debts of either of the transferor or the transferee is valid. A makes a gift of the house to B. The income arising from the house is 200 rupees per month. A gives a direction that the rent of the house, 200 rupees, should be applied in the payment of debt of amounting to 50,000 rupees. The direction is valid. 2. Accumulation for raising portions. The second exception relates to direction for accumulation of income for the purposes of providing portions for children or remoter issue of the transferor or any other person taking any interest. Under the transfer. Edwards vs. Tuck. 37 Digest 142. Lord Cranworth explained the meaning of portion by saying, a direction to accumulate all the person's property to be handed over to some child or children when they attain 21. Can never be said to be a direction for raising a portion for the child or children. It is not raising a portion at all, it is giving everything. Portion ordinarily means a part or share, which points to the arising of something out of something else for the benefit of some children or class of children. 3. Accumulation for preservation of property. The third exception is with regard to direction for accumulation for the purpose of the preservation or maintenance of the property transferred. Q. 14 describe vested interest and contingent interest with illustration. Distinguish between vested interest and a contingent interest. Is a vested interest defeated by the death of transferee before he obtains possession? Ans. Section 19 of Transfer of Property Act has defined the term vested interest as vested interest, where, on a transfer of property, an interest therein is created in favor of a person without specifying the time when it is to take effect, or in terms specifying that it is to take effect forthwith or on the happening of an event which must happen. Such interest is vested, unless a contrary intention appears from the terms of the transfer. A vested interest is not defeated by the death of the transferee before he obtains possession. Explanation. An intention that an interest shall not be vested is not to be inferred merely from a provision whereby the enjoyment thereof is postponed, or whereby a prior interest in the same property is given or reserved to some other person, or whereby income arising from the property is directed to be accumulated until the time of enjoyment arrives, or from a provision that if a particular event shall happen the interest shall pass to another person. This section, Section 19, and Section 119 of Succession Act, 1925 give expression to the English notion of vested interest, and makes it the law of the land except in case of Mohammedans. So an interest is said to be vested when it is not subject to any condition precedent, i.e. when it is to take effect immediately or on the happening of some event which is certain. An estate or interest is vested when there is an immediate right of present enjoyment or a present right of future enjoyment. An intention of person creating the interest must be gathered from the language employed by the grantor in the grant, giving the plain and natural meaning of words employed. Thus, when an interest is vested, it becomes the property of the transferee and is under Section 6 transferred by him even before he has obtained possession. If the transferee dies, his interest vests in his legal representatives whether or not he has obtained possession. Indeed, there is a strong presumption that on a transfer of property, the transferor intends to confer a vested interest in the transferee. A makes a gift to B of 100 rupees to be paid to him on the death of C. B gets a vested interest, as the event, namely, C's death is certain. B. A property is transferred to A for life and after his death to B here, although a prior interest in favor of A intervenes. But B's interest is vested as the determination of A's interest is a certain event. Then Section 20 of Transfer of Property Act deals with creation of vested interest in favor of unborn person. Section 20 lays down, where on a transfer of property, an interest therein is created for the benefit of a person not then living, he acquires upon his birth. Unless contrary intention appears from the terms of the transfer a vested interest, although he may not be entitled to enjoyment thereof immediately on his birth. So where the transferor expresses his intention that the property should not vest in unborn transferee until some time after his birth or makes the vesting contingent on the happening of an uncertain event, the vesting will be postponed till the time specified arrives, but in no case vesting of interest can be postponed beyond the limit laid down by Section 14 of the Act. So once it is admitted that gift to unborn child did not offend Section 13 or 14 of the Act, they acquire a vested interest the moment the child born U.S. 20 of the Act. In Rajesh Kanta vs. SMT. Shanti Devi, Hair 1957 South Carolina 255 question arose as to whether interest taken by beneficiaries under a trust is a vested or contingent interest. In this case, one Ramani Kanta Roy executed a registered trust deed in respect of his properties, and his eldest son Rajesh Kanta Roy was appointed sole trustee to manage properties subject to powers and obligations. After the execution of trust deed, Ramani Kanta died. Clause 12 of the deed was the main under which Rajesh Kanta and his brother Ramendra Kanta Roy got any interest in the properties. This clause showed that lots I to IV of the properties ultimately went to Rajesh and lot V alone went to Ramendra. But the interest which either of them was to get in the properties allotted to each was expressed to be one which each would get after the termination of the trust. It was only after the happening of two events, viz. I. The discharge of all the debts specified in the schedule, including the debts if any which might be incurred by the trustee for the payment of settlor's debts, and e. the death of the settlor himself, that the trust was to come to an end. It was on coming to an end of the trust that the sons were to get the properties allotted to them. The question was whether the interest created by the trust deed was vested or contingent. Supreme Court observed, death of a person is certain and not an uncertain event. So mere fact that a transferee is not entitled to immediate enjoyment does not necessarily make the interest a contingent one. It was thus held that interest taken by two brothers under the trust deed was a vested interest. So far as the fact that settlor attached great importance to the liquidation of debts. Supreme Court observed that there is nothing to show that settlor was apprehensive that debt would remain undischarged and that he considered the ultimate discharge of debt to be an uncertain event. Therefore sons took the vested interest, but only enjoyment was burdened till liquidation of debt. Contingent interest. Section 21 of the Act says, whereon a transfer of property and interest therein is created in favor of a person to take effect only on the happening of a specified uncertain event, or if a specified uncertain event shall not happen, such person thereby acquires a contingent interest in the property. Such interest becomes a vested interest in the former case on the happening of the event, in the latter, when the happening of the event becomes impossible. Exception, where, under a transfer of property, a person becomes entitled to an interest therein upon attaining a particular age, and the transferor also gives to him absolutely the income to arise from such interest before he reaches that age, or directs the income or so much thereof as may be necessary to be applied for his benefit, such interest is not contingent. An interest created on a transfer of property in favor of a person is said to be contingent when it is expressed to take effect, 1. On the happening of a specified uncertain event, or 2. If a specified uncertain event shall not happen. Such interest becomes a vested interest, in the former case on the happening of the event and in the latter case when the happening of the event becomes impossible. 1. A property is transferred to D in case A, B and C shall all die under the age of 18. D has contingent interest in the property until A, B and C all die under 18. 2. An estate is transferred to A for life and after his death to B if B shall then be living, but if B shall not then be living to C. B and C each take a contingent interest in the estate until the event which is to vest it in one or the other has happened. 3. An estate is transferred to A when she shall attain the age of 18 or shall marry under that age with the consent of B, with a proviso that if she neither attains 18 nor marries under that age with B's consent, the estate shall go to C. A and C each take a contingent interest in the estate. A attains the age of 18. A becomes absolutely entitled to the estate although she may have married under 18 without the consent of B. Distinction between vested and contingent interest. Vested interest. Contingent interest. Definition. 1. A vested interest is created in favor of a person, without specifying the time when it is to take effect, or specifying that it is to take effect forthwith, or on the happening of a certain event. 1. A contingent interest is created in favor of a person, to take effect only on the happening or not happening of a specified uncertain event, which may or may not happen. Nature. 2. It is ownership. 2. It is only a chance of becoming an owner. However, it is different from spare successions. Fulfillment of condition. 3. It does not depend upon the fulfillment of any condition. It creates an immediate right, though the enjoyment may be postponed to a future date. Thus the owner's title is already perfect. 3. It is solely dependent upon the fulfillment of the condition, after which it becomes a vested interest, so that if the condition is not fulfilled, the interest may fall through. Thus, The owner's title is as yet imperfect, but is capable of becoming perfect. Effect of transferee's death. 4. It is not defeated by death of transferee before he obtains possession. 4. Whether it passes on the death of the transferee or not depends on the nature of the contingency. Whether transferable and heritable. 5. It is both transferable as well as heritable. If the transferee of a vested interest dies before actual enjoyment, it passes on to his heirs. 5. It is transferable. Whether it is heritable or not depends upon contingency. If transferee dies before obtaining possession, contingent interest fails and does not pass on to his heirs. Present right of enjoyment. 6. In a vested interest there is a present and immediate right even when its enjoyment is postponed. 6. There is no present right of enjoyment. There is mere promise for giving such right, and such promise may be nullified by the failure of the condition. Transfer to members of a class who attain a particular age. Section 22 of TP Act provides that where, on a transfer of property, an interest therein is created in favor of such members only of a class as shall attain a particular age, such interest does not vest in any member of the class who has not attained that age. This section contemplates a transfer to a contingent class. Thus a gift to such of the children of a as shall attain the age of 18 is a gift to a contingent class. No child of A has a vested interest constitutes a condition which must be fulfilled before any one of them can take. In other words, until those persons attain that age they have a contingent interest. A fund is transferred to such of the children A as shall attain the age of 18. No child of A who is under the age of 18 has a vested interest in the fund. Transfer contingent on happening of specified uncertain event. Section 23 of the Act lays down that where, on a transfer of property, an interest therein is to accrue to a specified person if a specified uncertain event shall happen, and no time is mentioned for the occurrence of that event, the interest fails unless such event happens before or at the same time as the intermediate or precedent interest ceases to exist. Sections 23 and 24 deal with the case of a transfer which may become vested at a date not exactly specified on the happening of a specified uncertain event. In order that such interest which is at the outset contingent, may become vested, it is essential that the event must happen before or at the same time as the prior interest ceases to exist. The object of the section is to prevent property from remaining without any owner. Transfer to such of certain persons as survive at some period not specified. Section 24 provides that where, as a transfer or property, an interest therein is to accrue to such of certain persons as shall be surviving at 30 period, but the exact period is not specified. The interest shall go to such of them as shall be alive when the intermediate or precedent interest ceases to exist, unless a contrary intention appears from the terms of transfer. Q. 15 discuss following. A. The rule of acceleration of subsequent interest on failure of prior disposition. B. A conditional limitation is a condition subsequent as regards the prior interest and condition precedent as regards the ulterior interest. C. The effect of an interest created on transfer of property and dependent upon a condition on which a condition is attached. I. If a condition precedent is void. E. If a condition subsequent is void. Uns. Rule of acceleration of subsequent interest. A. This rule of acceleration of the subsequent interest on failure of prior disposition is mentioned in Section 27 of the Transfer of Property Act, which lays down where, on a transfer of property, an interest therein created in favor of one person, and by the same transaction an ulterior disposition of the same interest is made in favor of another. If the prior disposition under the transfer shall fail, the ulterior disposition shall take effect upon the failure of prior disposition. Although the failure may not have occurred in the manner contemplated by the transferor. But, where the intention of the parties to the transaction is that the ulterior disposition shall take effect only in the event of the prior disposition failing in a particular manner, the ulterior disposition shall not take effect unless the prior disposition fails in that manner. Illustrations. 1. A transfers 500 rupees to B on condition that he shall execute lease within 3 months after his death, and, if he should neglect to do so, to see B dies in his lifetime. The disposition in favor of C takes effect. 2. A transfers property to his wife, but, in case she should die in his lifetime, transfers to B that which he had transferred to her. A and his wife perish together under circumstances which make it impossible to prove that she died before him. The disposition in favor of B does not take effect. We see that the section enunciates the doctrine of acceleration. Thus, where there is a gift in remainder, expectant on the termination of an estate for lifi, and the prior life estate becomes void, the gift does not fall but is accelerated. Ajodhya vs. Raldman, 10 Cal. 482, PC. B. Conditional limitation. A conditional limitation is one containing a condition which divests an estate that has vested and vests it in another person. As regards the prior interest it is condition subsequent, but as regards the ulterior interest it is condition precedent. This rule is embodied in Section 28, which provides, on a transfer of property an interest therein may be created to accrue to any person with the condition superadded that in case a specified uncertain event shall happen such interest shall pass to another person, or that in case a specified uncertain event shall not happen such interest shall pass to another person. In each case the dispositions are subject to the rules contained in sections 10, 12, 21, 22, 23, 24, 25 and 27. Illustrations. I. A sum of money is bequeathed to a to be paid to him at the age of 18, if he shall die before he attains that age. To B. A takes a vested interest in the legacy, subject to being divested, and to go to B, in case A shall die under 18. E. A sum of money is bequeathed to A for life, and after his death to B, but if B shall then be dead leaving a son, such son is to stand in the place of B. B takes a vested interest in legacy subject to being divested if he dies leaving a son during his lifetime. C. I. Effect of interest created on transfer dependent upon condition precedent. Section 25 lays down the principle that an interest created on a transfer of property and dependent upon a condition precedent fails if the condition is void. It says, an interest created on a transfer of property and dependent upon a condition fails if the fulfillment of the condition is impossible, or is forbidden by law, or is of such nature that, if permitted, would defeat the provisions of any law, or is fraudulent, or involves or implies injury to the person or property of another, or the court regards it as immoral or opposed to public policy. The fulfillment of a condition may become impossible either at the time interest is created or subsequently, but in either case the transfer will fail. When the fulfillment of a condition becomes impossible by act of God, the condition becomes void and the transfer fails. But if the performance of the condition becomes impossible by the fraud of a person interested in non-fulfillment of the condition, the condition shall as against him be deemed to have been fulfilled. Such conditions precedents have been declared void simply because Section 60(b) of TP Act does not permit any transfer to be made whose object is illegal within the meaning of Section 23 of Indian Contract Act. Thus, where a donor made a gift of his property to a man and his wife on condition that he should have physical enjoyment of the woman, it was held in Ghumna vs. Ramchandra 47 all. 619 void. Section 26 of Act says where the terms of transfer of property impose a condition to be fulfilled before a person can take an interest in property, the condition shall be deemed to have fulfilled if it has been substantially complied with. Condition subsequent. In the case of condition subsequent, the estate will be or becomes absolute and the condition be ignored. Thus, if a gift was made with a condition superadded that donee should marry a certain person on or before she attained the age of 21 years, and the person named died before she attained that age, it was held that fulfillment of condition subsequent having become impossible, the estate became absolute. Section 28 of the Act says, on a transfer of property an interest therein may be created to accrue to any person with the condition superadded that in case a specified uncertain event shall happen such interest shall pass to another person, or that in case a specified uncertain event shall not happen such interest shall pass to another person. In each case the dispositions are subject to the rules contained in sections 10, 12, 21, 22, 23, 24, 25 and 27. Q. 16. He who accepts the benefits under the instrument, must adopt the whole of it. Explain. Explain the doctrine of election. Ans. Doctrine of election is one of the important rule of transfer of property which has been explained in Section 35 of Transfer of Property Act. Section 35 says, election when necessary. Where a person professes to transfer property which he has no right to transfer, and as part of the same transaction confers any benefit on the owner of the property, such owner must elect either to confirm such transfer or to dissent from it, and in the latter case he shall relinquish the benefit so conferred, and the benefit so relinquished shall revert to the transferor or his representative as if it had not been disposed of. Subject nevertheless, where the transfer is gratuitous, and the transferor has, before the election, died or otherwise become incapable of making a fresh transfer. And in all cases where the transfer is for consideration to the charge of making good to the disappointed transferee the amount or value of the property attempted to be transferred to him. The farm of Sultanpur is the property of C and worth 800 rupees. A by an instrument of gift professes to transfer it to B, giving by the same instrument 1000 rupees to C elects to retain the farm. He forfeits the gift of 1000 rupees. In the same case, A dies before the election. His representative must out of the 1000 rupees pay 800 rupees to B. The rule in the first paragraph of this section applies whether the transferor does or does not believe that which he professes to transfer to be his own. A person taking no benefit directly under a transaction, but deriving a benefit under it indirectly, need not elect. A person who in his one capacity takes a benefit under the transaction may in no other descend therefrom. Exception to the last preceding four rules. Where a particular benefit is expressed to be conferred on the owner of the property which the transferor professes to transfer, and such benefit is expressed to be in lieu of that property. If such owner claims the property, he must relinquish the particular benefit, but he is not bound to relinquish any other benefit conferred upon him by the same transaction. Acceptance of the benefit by the person on whom it is conferred constitutes an election by him to confirm the transfer. If he is aware of his duty to elect and of those circumstances which would influence the judgment of reasonable man in making an election, or if he waives inquiry into the circumstances, such knowledge or waiver shall, in the absence of evidence to the contrary, be presumed. If the person on whom the benefits has been conferred has enjoyed it for 2 years without doing any act to express dissent, such knowledge or waiver may be inferred from any act of his which renders it impossible to place the persons interested in the property professed to be transferred in the same condition as if such act had not been done. A transfers to B an estate to which C is entitled, and as part of the same transaction gives C a coal mine. C takes possession of the mine and exhausts. He has thereby confirmed the transfer of the estate to B. If he does not within 1 year after the date of the transfer signify to the transferor or his representatives his intention to confirm or to dissent from the transfer, the transferor or his representatives may, upon the expiration of that period, require him to make his election, and if he does not comply with such requisition within a reasonable time after he has received it, he shall be deemed to have elected to confirm the transfer. In case of disability, the election shall be postponed until the disability ceases, or until the election is made by some competent authority. So doctrine of election is that where a deed or a will professes to make a general disposition of property for the benefit of person named in it, such person cannot accept the benefit under the instrument without, at the same time, conforming to all its provisions and renouncing every right inconsistent with them. The principle of election enables the court to secure a just distribution of property in substantial accordance with the terms of instrument. The doctrine of election proceeds from the principle of equity. In C.B. Pathoma and others versus Velazari Shankara Narayan Kadamboli Thanya and others, Air 1965 South Carolina 241, it was observed that the doctrine of election may be stated thus: he who accepts a benefit under a deed or will or other instrument must adopt the whole contents of that instrument, must conform to all its provisions and renounce all rights that are inconsistent with it. This principle is often put in another form, that a person cannot approbate and reprobate the same transaction. In Valiammai vs. Nagappa, Air 1967 South Carolina 1153, it was observed that a case of election arises only when the transferee takes a benefit under a transaction. When the transferred derives any benefit indirectly, no question of election arises, as he, in that case, cannot be said to "take" under the deed. Section 35 sets forth the conditions whereby a person is put to election or act of choosing between two alternatives or inconsistent rights. The conditions are: 1. The transfer must profess to transfer a property which he has no right to transfer. It is immaterial whether in doing so he knows or does not know it to be not his property. 2. He must confer a benefit on the owner of the property transferred. 3. The transfer and the conferring of the benefit must form parts of the same transaction. 4. The benefit must be directly conferred on him. 5. The benefit must be conferred on him in the same capacity in which he is the owner of property. Where the owner dissents from the transfer: 1. He must relinquish the benefit conferred upon him. 2. The benefit intended for him would then revert to the transferor. Illustration: the farm of Sultanpur is the property of C, and worth 800 rupees. By an instrument of gift professes to transfer it to B, giving by the same instrument 1000 rupees to C. C elects to retain the farm. He forfeits the gift of 1000 rupees. Similarly, Section 127 of TP Act lays down that where a gift is in form of a single transfer to the same person of several things of which one is, and others are not burdened by an obligation, the donee can take nothing by the gift unless he accepts it fully. In other words, the donee must take all or none. This is based on equitable doctrine of election, namely that a person who accepts a benefit under an instrument must adopt the whole of it, conforming to all its provisions, and relinquishing every right inconsistent with it. Q. 17 discuss the law as to apportionment. Uns. Section 36 of TP Act lays down as: in the absence of a contract or local usage to the contrary, all rents, annuities, pensions, dividends and other periodical payments in the nature of income shall, upon the transfer of the interest of the person entitled to receive such payments, be deemed, as between the transferor and the transferee, to accrue due from day to day, and to be apportionable accordingly, but to be payable on the days appointed for the payment thereof. The appointment frequently denotes not but distribution, and in its ordinary technical sense, the distribution of one subject in proportion to another previously distributed. Sections 36 and 38 of TP Act are based on Sections 2, 3 and 7 of Apportionment Act 1870 of England. Some properties yield an income which is periodical. Upon transfer of such property, question as to apportionment of periodical income arising from such property between transferor and transfer arises. Though Section 8 of the Act gives general rule that upon transfer of a property, all the interests which transferor is then capable of passing in the property passes through to transferee. But Section 8 has no application. Section 36 says that all periodical payments shall be deemed to accrue from day to day and be apportioned between transferor and the transferee on that basis. In S.K. Sattar S.K. Mohammed Chaudhary vs. Gundappa Amabadas Bukate, Air 1997 South Carolina 998, it was observed that provisions of Section 36 and 37 provides that even if the estate is in possession of a tenant who is under an obligation to pay rent, there can still be severance of such estate. However, it is important to point out that principles of Section 36 is not applicable to cases of partition of joint families and in the absence of a contract or other circumstances showing contrary intentions. The presumption in such case ought to be that rent or profit accrued to the joint family even before the date of the partition but not realized till then would belong to that co-sharer to whom has been allotted the interest of the family in property in respect of which such rent of profit has accrued. Section 37 of the Act then provides. Section 37 of the Act provides about benefit of obligation on severance. It lays down as under. When in consequence of a transfer property is divided and held in several shares and thereupon the benefit of any obligation relating to the property as a whole passes from one to several owners of the property, the corresponding duty shall, in the absence of a contract to the contrary amongst the owners, he performed in favor of each of such owners in proportion to the value of his share in the property provided that HTE duty can be severed and that the severance does not substantially increase the burden of the obligation. But if the duty cannot be severed or if the severance would substantially increase the burden of the obligation, the duty shall be performed for the benefit of such one of several owners as they shall jointly designate for that purpose, provided that no person on whom the burden of the obligation lies shall be answerable for failure to discharge it in manner provided by this section unless and until the state government by notification in the official gazette so directs. A sells to B, C, and D a house situated in a village and leased to A on an annual rent of 30 rupees, and delivery of one fat sheep. B having provided half the purchase money and C and D 1/4 each. A having notice of this must pay 15 rupees to B, 7 rupees and 50 paise to C, 7 rupees and 50 paise to D and must deliver the sheep according to the joint direction to B, C and D. B. In the same case each house in the village being bound to provide 10 days labor each year on a dike to prevent inundation. A had agreed as a term of his lease to perform this work for A. B, C and D severally require A to perform 10 days' work due on account of the house of each. A is not bound to do more than 10 days' work in all according to such direction as B, C and D may join in giving. Q. 18 describe a. Transfer by person authorized under special circumstances. B. Transfer where third person is entitled to maintenance. Uns. A. Transfer by person authorized under special circumstances. Section 38 of the Act says that where a Hindu widow or the manager of Hindu family or the guardian of a minor who is authorized to dispose of a movable property only under certain circumstances transfers a movable property for consideration, alleging the existence of such of circumstances as between the transferee and transferor and other persons affected by the transfer. Such circumstances shall be deemed to have existed, if the transferee, I, has used reasonable care to ascertain the existence of such circumstances, and, E, has acted in good faith. In Hanuman Prasad Pandey vs. Babui Munraj Kunwar, 1856, 6 MIA 393, where a mortgage had been executed by the manager of an infant, who, under the Hindu law, has only a limited and qualified power of disposal over the minor's immovable property and can alienate if only for the minor's needs or for the benefit of the estate. The principle was followed before the TP Act and has now been embodied in Section 38 of the Act. The principal object of the section is not only to protect innocent transferees for value, but also to protect other persons affected by the transfer such as reversioners. And the effect that where a transfer is alleged to be for legal necessity and such necessity cannot be established by direct evidence, it will be deemed to exist, i.e. if it can be shown that the transferee has taken reasonable care to ascertain if such circumstances existed and has acted in good faith. Section 38 of the TP Act lays down that where any person, authorized only under circumstances in their nature variable to dispose of a movable property transfers such property for consideration alleging the existence of such circumstances, they shall, as between the transferee on the one part and the transferor and other persons, if any, affected by the transfer on the other part be deemed to have existed, if the transferee, after using reasonable care to ascertain the existence of such circumstances has acted in good faith. A Hindu widow, whose husband has left collateral heirs, alleging that the property held by her as such is insufficient for her maintenance agrees for purposes neither religious nor charitable to sell a field, part of such property to B satisfies himself by reasonable inquiry that the income of the property is insufficient for his maintenance, and that the sale of the field is necessary and, acting in good faith, buys the field from A as between B on the one part and A and the collateral heirs on the other part. A necessity of the sale shall be deemed to have existed. Thus, the transferee of an immovable property from a person who is authorized to alienate under certain circumstances, for example, legal necessity is protected if the following conditions are satisfied. 1. The transfer is for consideration. 2. The transferor is authorized to transfer under certain circumstances. 3. The transferee has used reasonable care to ascertain the existence of such circumstances. 4. Transferee has acted in good faith. Distinction between sections 38 and 41. Section 38 comes into operation where the transferor has a power to transfer immovable property. Under the particular circumstances, and a transfer under the circumstances would be binding on all persons interested in the property. Section 41 applies to cases where the transferor has no power to transfer the property, but the transfer is nevertheless binding on the real owner on the principle of estoppel. This section is not applicable to transfer by ostensible owner, under Section 41 of this Act, and transfers made by trustees, under Section 64 of the Trust Act, whose own authority of transfer is also limited. B. Transfer where third person is entitled to maintenance. In a case of transfer where third person has a right to receive maintenance, Section 39 of the TP Act provides as follows. Where third person has a right to receive maintenance, or a provision for advancement of marriage, from the profits of a movable property, and such property is transferred, the right may be enforced against the transferee, if he has notice thereof or if the transfer is gratuitous, but not against a transferee for consideration and without notice of the right against such property in his hands. This section is intended to protect persons who are entitled to receive maintenance or for whom provision is made for advancement or marriage from the profits of any immovable property. Prior to the amendment in 1929, the section provided that such a right could be enforced against a transferee of the property if the transfer has been made with the intention of defeating the right and transferee had the notice of the intention. The court, therefore, always required proof of the intention. In actual practice, it was almost impossible to adduce proof of mere intention. In order to enable such proof to be adduced, a transferor must have announced his fraudulent intention of defeating the rights of persons entitled to maintenance, and the transferee must have heard him doing so. To remove this difficulty and particularly to protect persons entitled to maintenance, it was considered necessary that the reference to the transferor's intention should be omitted from the section. With this object in view, the section was amended accordingly. Thus, a person having a right to receive maintenance out of the profits of a movable property can enforce his right against the transferee of the said immovable property under the following circumstances. I. When the transfer is for valuable consideration but the transferee has notice of such right, or E. When the transfer is gratuitous. It is not necessary to prove in either case that the transfer was made with the intention of defeating such right. But the right cannot be enforced against transferee for consideration and without notice of such right. Q. 19. A Hindu widow whose husband has left collateral heirs alleging that the property held by her as such is insufficient for her maintenance, agrees for purposes neither religious nor charitable to sell a field of such property to B. satisfies himself by reasonable inquiry that the income of the property is insufficient for his maintenance and that the sale of the field is necessary and, acting in good faith, buys the field from a collateral heir. Files a suit to set aside the sale alleging that there was no necessity for the sale. Decide. B. A transaction of sale of a movable property has entered into by the husband after coming to know that the wife was going to present a suit for maintenance. decide if it was a bona fide transfer and whether the property could be charged for ensuring payment of maintenance. Uns. A. C. Suit must be dismissed. Under Section 38, Transfer of Property Act, where any person, authorized only under certain circumstances to dispose of a movable property, transfers such property. 1. For consideration. 2. Alleging of existence of circumstances authorizing the transfer. 3. The transferee has taken reasonable care to ascertain whether the circumstances exist, and 4. He has acted in good faith, then those circumstances would, as between the transferor and any person affected by the transfer, be deemed to have been present. According to this section, therefore, when a transferee takes a transfer from a person whose power of transfer is limited and qualified, it is duty of the transferee to ascertain whether the circumstances justifying the transfer exist. If he makes reasonable inquiries and acts honestly, he is protected. In the above case, B satisfied himself by reasonable inquiry that the income of the property was insufficient and that the sale of the field was necessary. In these circumstances B is protected and C cannot challenge the validity of the sale. B. Section 39 of the Transfer of Property Act provides that a person having a right to receive maintenance out of the profits of a movable property can enforce his right against the transferee of the said immovable property under the following circumstances. I. When the transfer is for valuable consideration but the transferee has notice of such right, or E. When the transfer is gratuitous. In the given problem, the transaction of sale of a movable property was entered into by the husband after coming to know that the wife was going to present a suit for maintenance. Hence the same could not be said to be a bona fide transfer without notice, and therefore the property could be charged for ensuring payment of maintenance without voiding the sale deed. Q. 20. What is the covenant? What are covenants annexed to land? Bring out the distinction between affirmative and negative covenant. Uns. Covenant. Covenant in simple words means agreement or a promise. In England, a contract contained in a sealed instrument is called a covenant. The person bound by the promise is called the covenanter, and the person entitled to the benefit of it is called the covenantee. Section 11, second paragraph, and Section 40 of TP Act refers to affirmative and negative covenants in a transfer. Section 40 lays down as under, where, for the more beneficial enjoyment of his own immovable property, a third person has, independently of any interest in the immovable property of another or of any easement thereon, a right to restrain the enjoyment in a particular manner of the latter property, or of obligation annexed to ownership but not amounting to interest or easement. Where a third person is entitled to the benefit of an obligation arising out of contract and annexed to the ownership of a movable property, but not amounting to an interest therein or easement thereon. Such right or obligation may be enforced against a transferee with notice thereof or a gratuitous transferee of the property affected thereby, but not against a transferee for consideration and without notice of the right or obligation, not against such property in his hands. A contracts to sell Sultanpur to B. While the contract is still in force, he sells Sultanpur to C, who has notice of the contract. B may enforce the contract against C to the same extent as against A. Section 40 of the Transfer of Property Act refer to affirmative and negative covenants in a transfer. Covenant means agreement or promise. Such agreements may be either affirmative or negative. An affirmative covenant is an agreement between the transferor and the transferee whereby the transferee affirms or undertakes to do something. For example, an agreement requiring the expenditure of money is an affirmative covenant. Affirmative covenants are collateral. They are not annexed to the land, i.e., do not run with the land. In a negative or restrictive covenant, the transferee binds himself to use or abstains from using certain property. In other words, it is an agreement restrictive of the user of the land, is in the nature of an easement restricting the use or enjoyment of certain land. For example, where the owner of the land undertakes or covenants to use the premises for private residence only, or to keep certain windows obscured, or not to build, not to open a public house, not to use for business purposes, such covenants are negative in substance. The distinction between an affirmative and a negative covenant may further be explained by the illustrations. 1. A. The owner of a vacant plot of land sold the plot to B by sale deed which contained a covenant that B and his heirs would keep the plot uncovered with buildings, that is, he would not build. This is a restrictive or negative covenant. 2. A sold his land to B. The sale deed contained a covenant that B would lay out money in building or repairing. This is an affirmative covenant, i.e., an obligation to do something. Under the second paragraph of Section 11, the transferor may impose conditions restraining the enjoyment of land if such restrictions are for the benefit of his adjoining land. Suppose the occupying owner of plot X sells northern half of the land to B absolutely but takes a covenant from B that no shops shall be erected on the purchased part, or suppose that A, the owner of plot X, sells the northern half of the plot X absolutely but takes a covenant from B that B shall carry on annual repairs to a drain passing through the purchased part. The former covenant is known as affirmative and the latter negative. Both affirmative and negative covenants continue to bind A and B personally, but the problem that requires consideration is whether the covenants bind persons who subsequently acquire B's land and further whether the covenants are reinforceable by persons who later acquire the southern part of plot X originally retained by A if the restriction imposed by the covenant constitutes an easement. Then it binds the servient heritage permanently. In case it is not an easement, then this section applies. Under this section, A or his assignee can enforce a negative covenant against the assignee of the transferee provided I. The restriction is one the burden of which runs with the land, and E. The assignee has notice of the restriction or paid no consideration. A owns two properties X and Y and sells X to B. B covenants that he shall keep open a portion of X adjoining Y and not build upon it. If B sells X to D and D has notice of the covenant, B can refrain D from building in case he attempts to do so. Similarly, if A has sold Y to C after the sale to B, C has a similar right to enforce the covenant against D. Covenants annexed with land. A covenant is said to be annexed with the land when it binds the land in its inception or affects the nature, quality or the value of land. The benefit of such a covenant runs with the land for the benefit of which it is expressed to be made. When a covenant was imposed by vendor as owner of other land of which the land sold formed a part for the benefit of the unsold land, it is annexed to the unsold land so as to run with it, or in other words, its benefit runs with the whole of the land for the benefit of which it was expressed to be made, and not only the original convenantee but his transferee or successor in interest of entire land can enforce the covenant. A covenant can be said to touch and concern the land when it is one which affects the nature or value of the land or benefits the land. What is essential for the effective annexation of a covenant to a land is the intention of original parties to the covenant. For discovering which, court has to look to the wordings of covenant and the surrounding circumstances. If they show either that the covenant binds the land in its inception or if affects the nature, quality or value of the land, it will go with the land to the transferee as being annexed to it. The expression, covenant runs with the land, is the exception to the general rule that all covenants are personal. See Air 1970, South Carolina 1872, 1875. Q. 21. Who is an ostensible owner? Discuss the law relating to transfer by an ostensible owner. Uns. Section 41 of TP Act deals with transfer by an ostensible owner. An ostensible owner is one who has all the indicia of ownership without being the real owner. Section 41 says, where, with the consent, express or implied, of the persons interested in immovable property, a person is the ostensible owner of such property and transfers the same for consideration. The transfer shall not be voidable on the ground that the transferor was not authorized to make it, provided that the transferee, after taking reasonable care to ascertain that the transferor had power to make the transfer, has acted in good faith. The principle embodied in Section 41 is an exception to the general rule that a person cannot pass a better title in the property than he himself has, and the result could be avoided only under the equitable principle of estoppel laid down in Section 41. So general principle of law of transfer of property that no man can transfer to another a right or title greater than what he himself possesses, and Section 41 contains exception to this general rule. That if the true owner permits another to hold himself out the real owner as by entrusting him with the documents of title or in some other way a third person who bona fide deals with that other may acquire a good title to property as against the true owner. For Section 41 to be invoked, 4 conditions have to be satisfied, which are: 1. The transferor is the ostensible owner. 2. He sold the property by consent, expressed or implied, of real owner. 3. Transfer is for consideration. 4. Transferee had acted in good faith, taking all reasonable care to ascertain that the transferor had power to transfer. For the applicability of this section, it is necessary that the transferor is an ostensible owner with express or implied consent of the real owner. Where the real owner is incapable of giving consent, e.g. minor or insane, and the transfer is made by an ostensible owner, this section is not applicable. Gurucharan Singh vs Punjab Electricity Board, Patiala, A1989P and H127. It is also necessary that the purchaser has exercised reasonable care and has purchased the property in good faith. Good faith means bona fide intention of the purchaser. If the purchaser has knowledge that transferor is an ostensible owner and has no authority, he cannot be said to have good faith. Where the transfer is collusive and false, there is no good faith, and Section 41 does not apply. Rai Sunil Kumar vs Thakur Singh, A. 1984, Pat 80. Ram Kumar vs McQueen. In Ram Kumar vs McQueen, 18 WR 166, the plaintiff brought the suit for recovery of the suit property which he claimed under the will of one MacDonald. The defendant's father had purchased the property from Bunnu Bibi, in whose name the property stood in the public register, having been purchased in her name from the original owner of the property. The plaintiff contended that Bunnu Bibi was only a benamidar for MacDonald, who had purchased the property in her name, and that she was not the real owner of the property. The defendant's father, however, had neither notice of the Benami title nor were there specific circumstances to leave the purchaser to institute an inquiry into the title. On these facts, the Privy Council held that the plaintiff was not entitled to recover upon his secret title. The Judicial Committee observed, "It is a principle of natural equity, which must be universally applicable, that where one man allows another to hold himself out as the owner of an estate, and the third person purchases it for value from the apparent owner in the belief that he is the real owner, the man who so allows the other to hold himself out shall not be permitted to recover upon his secret title, unless he cannot overthrow that of the purchaser by showing either that he had direct notice, or something which amounts to constructive notice, of the real title, or that there existed circumstances which ought to have put him upon an inquiry that, if prosecuted, would have led to a discovery of it." Note: by virtue of the Benami Transaction Act, 1988, the law relating to transfer by an ostensible owner has now been changed in India. With certain exceptions, ostensible owners are now made real owners. Q. 22 Explain the doctrine, feeding the grant by estoppel. Uns. Section 43 TP Act lays down the doctrine, feeding the grant by estoppel. It provides as follows. Where a person fraudulently or erroneously represents that he is authorized to transfer certain immovable property and professes to transfer such property for consideration, such transfer shall, at the option of the transferee, operate on any interest which the transferor may acquire in such property at any time during which the contract of transfer subsists. Nothing in this section shall impair the right of transferees in good faith or consideration without notice of the existence of the said option. A Hindu who has separated from his father B, sells to C 3 fields, X, Y and Z representing that A is authorized to transfer the same. Of these fields Z does not belong to A, it having been retained by B on the partition. But on B's dying A's heir obtains Z.C. not having rescinded the contract of sale. May require A to deliver Z to him. Section 43 applies to all kinds of transfer for consideration. Principle of feeding the grant by estoppel comes into play when a transfer is made by person who has no title to the property transferred but later on he acquires title to that property. So Section 43 laid down the rule of estoppel, which is not the estoppel which is a rule of evidence preventing a party from alleging and proving the truth of facts. It is a kind of estoppel which affects legal relations. Essentials. To attract the application of the section, the conditions required for invoking the doctrine are as follows. 1. The transferor should have made a fraudulent or erroneous representation that he had authority to transfer the property while actually he did not. 2. The transferee should have acted on the representation and he should not have knowledge of the fact that the transferor had no authority. 3. The transfer is for consideration. 4. The transfer should not have been one forbidden by law. 5. The transfer subsequently acquires an interest in the property. 6. The contract is subsisting and has not been cancelled. 7. The transferee exercises his option and asks the transferor to make good and transfer the property contracted to be transferred. 8. The property should not have been purchased by other person for value without notice of prior transfer. In Banwari Lal vs. Sukhdarshan Dayal, Air 1973 South Carolina 814, it has been held by Supreme Court that estoppel is a rule of evidence and except in cases like those under Section 43 TP Act. When a grant is led by estoppel, the rule does not operate to create interest in property regarding which the representation is made. The doctrine is applicable only to the transfers of properties for value. It is not applicable where the transfer is gratuitous, i.e. without consideration. Thus where the property has been transferred by way of gift. The provisions of Section 43 are not applicable because a gift of a property in which the donor has no present fixed right at the date of the transfer is void, as per Section 124 TP Act. Q. 23. What is the distinction between Section 43 of the TP Act and Section 115 of Indian Evidence Act? Discuss. Ans. Under Section 43 of TP Act, when the transferor subsequently acquires interest in the property, the transfer operates at once at the option of the transferee. The new interest stands transferred, at the option of the transferee at once to him. But under Section 115 no such thing happens. Under that section the transferor is only precluded from denying that he did not have any interest in the property at the time of transfer. In the undernoted case, A mortgaged his share as well as his mother's share in a property. In execution of the decree for sale, obtained on the mortgage, B purchased the property. Subsequently, A got the interest of his mother on her death. It was held that B could get the benefit of Section 43 of TP Act. But Section 115 applied and A was stopped from denying his title. The section applies only to cases where the invalidity of a transfer is due merely to the transferor, either I. not having a title, or e. having only a defective title, in which cases the subsequent acquisition of a good title enable the transferee to claim the benefit to that good title, but it can have no application where to the knowledge of the transferee the transfer is forbidden. It is to be noted that the doctrine of estoppel is not fully recognized in Section 43 of the Act. Estoppel has been adopted by this section only to the extent that the subsequent estate passes to the transferee without any further act on the part of the transferor. Q. 24 describe transfer by one co-owner and joint transfer for consideration, and also discuss the transfer for consideration by persons having distinct interests in transfer by co-owners of shares in common property, or distinguish between joint tenancy and tenancy in common. Uns. Transfer by a co-owner. The interest of a co-sharer in common property can be sold, mortgaged or leased to another co-sharer or to a stranger. Section 7, 8 and 44 recognize the validity of such transfer. Section 44 lays down as under: where one or two or more co-owners of a movable property legally competent in that benefit transfers his share of such property or any interest therein the transferee acquires. As to such share or interest, and so far as is necessary to give effect to the transferor's right to joint possession or other common or part enjoyment of the property, and to enforce a partition of the same, but subject to the conditions and liabilities affecting, at the date of the transfer, the share or interest so transferred. Where the transferee of a share of a dwelling house belonging to an undivided family is not a member of the family, nothing in this section shall be deemed to entitle him to joint possession or other common or part enjoyment of the house. So Section 44 of the Act has two limbs. Under the first limb, the purchaser by the purchase acquires, inter alia, the right to joint possession of property along with the other co-sharers. Under the second limb, Section 44 does not entitle him to joint possession. Acquisition of right to joint possession and giving effect to such right are distinct questions. Second part of the section is designed to prevent an outsider from enforcing his way into a dwelling house in which other members of the transferor's family have right to live. Transfer by a co-sharer in order to be valid must satisfy following two conditions. A. Vendor should be in possession, either actual or constructive, of any portion of joint holding. B. That the land sold should not exceed the share held by co-sharer. Joint transfer for consideration. So far as joint transfer for consideration, Section 45 of the Act says, where a movable property is transferred for consideration to two or more persons and such consideration is paid out of a fund belonging to them in common, they are, in the absence of a contract to the contrary, respectively entitled to interests in such property identical, as nearly as may be the interests to which they were respectively entitled in the fund. And, where such consideration is paid out of separate funds belonging to them respectively, they are, in the absence of a contract to the contract, respectively entitled to interests in such property in proportion to the shares of the consideration which they respectively advance. In the absence of evidence as to interests in the fund to which they were respectively entitled, or as to the shares which they respectively advance. such person shall be presumed to be equally interested in the property. Section 45 of the Act refers to the cases in which property is transferred to two or more persons for consideration and there is no contract providing for the quantum of interest which each is to take. In the case where money is paid out of a fund belonging to the purchasers in common, the rule is that their interests in the property transferred shall be identical with their interests in the fund. But where the money is contributed by the transferees out of their separate funds, the section provides that they shall be respectively entitled in the property proportionate to their respective shares in the amount contributed. The proviso to the section lays down that if no evidence is led to show the respective interests of the transferees in the fund, or the shares which they respectively advance, such person shall be deemed to be equally interested in the property. Joint tenancy and tenancy in common. Distinction. Section 45 of Transfer of Property Act deals with the question whether the transferees take as joint tenants or tenants in common. The rule of English law is to presume that a transfer to a plurality of persons creates a joint tenancy with rights of survivorship, unless there are words of severance. A joint tenancy has been recognized in a gift by will of a native Christian, and the Parsi and also a Muslim. The Hindu rule is exactly opposite. In Jogeshwar Narain vs. Ramchand Dutt, the Privy Council said, the principle of joint tenancy appears to be unknown to Hindu law, except in case of coparcenary between members of an undivided family. Even if the grantees are members of a coparcenary, they will take as tenancy in common, unless a contrary intention appears from the grant. It has been held that in India the court must always lean against holding any particular bequest or grant as a joint bequest or joint grant. The presumption must always be in favor of a tenancy in common rather than joint tenancy. A joint tenancy may be severed and converted into tenancy in common by one of the joint tenants disposing of or contracting to sell his interest, or by mutual agreement or by a course of dealing by all the joint tenants sufficient to indicate a severance. A tenant in common is entitled to joint possession, and if excluded from such possession may sue for a declaration of his right. But if there is no exclusion or denial of his right, a tenant in common who gives up joint possession has no right to sue for a share of his joint profits. Entry by one co-tenants in the absence of clear proof to the contrary ensures for the benefit of all. If A and B are co-tenants of property of which A is in actual possession, and B sells his share to C, the possession of A is the possession of C. See Bishwanath vs. Rabija Khatun, 1933, 6 Okal. 616. But in a case where A and B were tenants in common, each in possession of a moiety and took possession of B's share on B's death by right of inheritance. His possession was adverse to a purchaser from B. See Krishna Chandra Das vs. Puran Chandra Das, 1935, 62 Cal. 305. Presumption of equality. In the absence of evidence showing in what share the consideration was paid, there is a presumption that the co-owners' interests are equal. In a case where A and B jointly purchased a property from C, A, paid the whole consideration to C but debited in his account books half the amount against B. B did not pay this amount to A but claimed half the property. It was held that B was entitled to half the property but that court should pass a decree therefore only on condition of B's paying up the amount 1912, 15 Ind. Cases 173, 173, all. Q. 25 Explain the doctrine of priority. Ans. Doctrine of priority. The principle of the rule in Section 48 of TP Act is based on the equitable maxim, qui prior est tempore potier est fire, which means that one which is first in time is better in law. However, it must be noted that rule of priority is invoked only when the interests created by transfer either at the sale or at different time conflict with each other and the transfers thus created are valid and complete transfers. Where the transfers create inconsistent rights, no question of priority would arise. But where they are of one type, the question arises as to which of them should precede the other. For instance, a mortgages his immovable property to BB would get few rights over the property. But A still remains the owner and has such a power to redeem the mortgage and can get the property back to himself. Now instead of redeeming the mortgage, A transfers that right to a third person altogether either by sale or mortgage. If it is a sale, he will have no interest in the property, and the vendee would be entitled to redeem the property from B. If it is a mortgage, then it would be a mortgage of the remaining rights. In that event there will be two mortgages, one in favor of B, and the other in favor of such other third person. Two mortgages have thus been created out of the same determination, though not exactly of the same character. The question for determination is which of the two mortgages stand first and has a better claim. The rule of priority in Section 48 is that whichever is executed first in point of time must be preferred to the other later in date. The section that where a person purports to create by transfer at different times rights in or over the same immovable property and such rights cannot at all exist or be exercised to their full extent together. Each later created right shall, in the absence of a special contract or reservation binding the earlier transferees, be subject to the rights previously created. Exception to the rules of priority. There are following exceptions to the rules of priority. 1. Section 50 of the Registration Act gives a subsequent registered deed priority over a prior unregistered deed of which registration is optional. But as optional registration has been abolished by this Act as regards sale deed by Section 54, and mortgage deed by Section 59. The scope of this exception is limited and is applicable only to those territories to which the Act does not extend. 2. When an instrument is executed by fraud, gross negligence or misrepresentation, the transferee cannot claim priority. Forfeiture of priority. Priority may be forfeited by fraud, misrepresentation or gross neglect on the part of the prior transferee. Q. 26 Describe the rights for rent bona fide paid to the holder under defective title and improvements made bona fide by holders under defective title. Or, discuss the doctrine of equitable estoppel. Ans. Section 50 TP Act provides that no person shall be chargeable with any rents or profits of any immovable property, which he has in good faith paid or delivered to any person of whom he in good faith held property, notwithstanding it may afterwards appear that the person to whom such payment or delivery was made, had no right to receive such rents or profits. A lets a field to B at a rent of 50 rupees and then transfers the field to CB having no notice of transfer, in good faith pays the rent to AB is not chargeable with the rent so paid. The Section 50 contemplates payment of rent in good faith for the same tenancy to a wrong person. The expression, good faith, will exclude cases where a person has acted in a grossly negligent manner, sufficient to charge him with notice of real owner's right. Section 50 protects a tenant in respect of any payment which he makes bona fide to a person from whom he held the property, though it subsequently turns out that the person to whom he made the payment had no right to it. Section 50 is subject to the doctrine of lis pendens, contained in Section 52, if therefore, the tenant makes any payment to the mortgagor during the pendency of suit for redemption. He does so at his own risk and he cannot claim protection under Section 50. Section 51 of TP Act lays down provisions for protection for improvements made by bona fide holder under defective titles as when the transferee of a movable property makes any improvement on the property, believing in good faith that he is absolutely entitled thereto, and he is subsequently evicted therefrom by any person having a better title. The transferee has a right to require the person causing the eviction either to have the value of the improvement estimated and paid or secured to the transferee, or to sell interest in the property to the transferee at the then market value thereof, irrespective of the value of such improvement. The amount to be paid or secured in respect of such improvement shall be the estimated value thereof at the time of the eviction. When, under the circumstances aforesaid, the transferee has planted or sown on the property crops which are growing when he is evicted therefrom, he is entitled to such crops and to free ingress and egress to gather and carry them. So Section 51 of Act is based upon the maxim that he who seeks equity must do equity. Section 51 is an exception to rule enunciated by the maxim, quia quid plantator solo sedet, and is a general provision dealing with improvements effected by a transferee to transferred property, while Section 63A of Act is a special provision dealing with improvements effected by a mortgagee in possession. In order that Section 51 may apply, it is essential that I, the person claiming relief under this section is a transferee of a movable property. E. He has made improvements believing in good faith that he was absolutely entitled to the property in. E. He is evicted therefrom by person with better title. In Air 1956 South Carolina 727 it was observed that Section 51 merely lays down an equitable principle and enables a court to determine the equities between the parties. Benefit of section is open only to bona fide occupants in their own right and not to squatters and trespassers. Even a lessee cannot claim compensation for improvements made by him. U.S. 51 of Act, his rights are controlled by Section 108 of Act. Q. 27 discuss the doctrine of lis pendens. Uns. Section 52 of TP Act lays down the doctrine of lis pendens as during the pendency in any court having authority within the limits of India excluding the state of Jammu and Kashmir, or established beyond such limits, by the central government of any suit or proceedings which is not collusive and in which any right to a movable property is directly and specifically in question. The property cannot be transferred or otherwise dealt with by any party to the suit or proceeding so as to affect the rights of any other party thereto under any decree or order which may be made therein, except under the authority of the court and on such terms as it may impose. Explanation. For the purposes of this section, the pendency of a suit or proceeding shall be deemed to commence from the date of the presentation of the plaint or the institution of the proceeding in a court of competent jurisdiction, and to continue until the suit or proceeding has been disposed of by a final decree or order and complete satisfaction or discharge of such decree or order has been obtained, or has become unobtainable by reason of the expiration of any period of limitation prescribed for the execution thereof by any law for the time being in force. So Section 52 is an expression of principle of the maxim, pendente lite nihil innovator, i.e. pending a litigation, nothing new should be introduced. Section 52 provides that pendente lite, neither party to the litigation, in which any right to a movable property is in question, can alienate or otherwise deal with such property so as to affect his opponent. So Section 52 is intended to protect the parties to litigation against alienations by their opponents during the pendency of the suit. It is important to point out here that wherever the TP Act is not applicable, the doctrine of lis pendens, which is based on justice, equity and good conscience principles as contained in Section 52 would still apply. In Abdul Aziz vs. District Judge, Air 1994 All. 167, it was observed that Section 52 comes into existence from the point of the institution of suit and continues to survive till the satisfaction of the decree. In K.A. Khader vs. Rajamma John Madathil, Air 1994 Kar. 122 It was observed that effective doctrine of lis pendens is embodied in Section 52 of TP Act is not to annul all voluntary transfers effected by the parties to a suit but only to render it subservient to the rights of the parties thereto under the decree or order which may be made in that suit. Its effect is only to make decree passed in the suit binding on the transferee, if he happens to be third-party person even if he is not a party to it. The transfer will remain valid subject, however, to the result of suit. The doctrine, as observed by Turner, L.J. in Bellamy vs. Sabina, 1987, the C&J 566, rests upon this foundation that it would plainly be impossible that any action or suit could be brought to a successful termination if alienations pendente lite were allowed to prevail. The plaintiff would be liable in every case to be defeated by the defendants, alienating before the judgment or decree. and would be driven to commence his proceedings de novo subject again to the same course of proceeding. Lord Cranworth in the same case explained that the doctrine did not rest on the ground of notice. He said, "It is scarcely correct to speak of lis pendens as affecting a purchaser through the doctrine of notice. It affects him not because it amounts to notice, but because the law does not allow litigant parties to give to others pending the litigation rights to the property in dispute, so as to prejudice the opposite party. The doctrine is, therefore, based upon expediency, and it is immaterial whether the transferee pendente lite had or had not notice of the suit." In M.S. Supreme General Films Exchange Limited vs. Brijanath Singh, AIR, 1975, SC 1810 Plaza Talkies, a theatre was attached in execution of a decree against the owner of a theatre. A lease of the same theatre was executed in favor of appellant company during the attachment. It was held by the Supreme Court that the lease is to be struck by the doctrine of lis pendens because the lease purported to create entirely new rightly pendente lite. Essentials of this section. I. There must be pendency of a suit or proceeding. E. The suit or proceeding must be pending in a competent court. E. The suit or proceeding must not be collusive. IV. A right to immovable property must be directly and specifically in question in that suit or proceedings. V. The property in dispute must be transferred or otherwise dealt with by any party to the litigation. V. The alienation must affect the rights of the other party. Effects of the doctrine. When a property is transferred pending the suit is not ipso facto void, but it is only voidable at the option of the party. It means the party can transfer the property pending the suit, but the transfer will not affect the rights of any party thereto under any decree. Exceptions. 1. Permission of the court. If a transfer is made with the permission of the court, then this doctrine cannot be attracted. 2. Law of insolvency. No transfer can be rendered as one fraudulent, if the same is effected under the law of insolvency for the time being in force. 3. Effects of fraud. A. Whether the fraud is inchoate, that means, a transfer which is made under a sham sale deed, but no property is actually conveyed to the transferee. B. When the fraud is accomplished or perfected. Q. 28. What is a fraudulent transfer? Is a transfer of immovable property made with intent to delay or defeat the creator of the transferor. Uns. Section 53 of TP Act says, 1. Every transfer of immovable property made with intent to defeat or delay the creditors of the transferor shall be voidable at the option of any creditor so defeated or delayed. Nothing in this subsection shall impair the rights of a transferee in good faith and for consideration. Nothing in this subsection shall affect any law for the time being in force relating to insolvency. A suit instituted by a creditor, which term includes a decree holder whether he has or has not applied for execution of his decree, to avoid a transfer on the ground that it has been made with intent to defeat or delay the creditors of the transferor, shall be instituted on behalf of, or for the benefit of all the creditors. 2. Every transfer of a movable property made without consideration with intent to defraud a subsequent transferee shall be voidable at the option of such transferee. For the purposes of this subsection, no transfer made without consideration shall be deemed to have been made with intent to defraud by reason only that a subsequent transfer for consideration was made. So Section 53 lays down that every transfer made with intent to defeat or delay the creditor is voidable at the option of the creditors so defeated or delayed. 1. There must be a transfer of a movable property. 2. The transfer must be made with intent to defeat or delay the creditors. If 3 above 2 conditions are fulfilled, the transfer is voidable at the option of the creditors. Exception: a transferee on good faith and for consideration is protected, that is, the creditors cannot set aside a transfer made to a person who has acted honestly and has paid consideration. Fraudulent transfers. This section is of 2 parts. The first part lays down that every transfer of a movable property made with intent to defeat or delay the creditors of the transferor shall be voidable at the option of any creditor so defeated or delayed. To take one illustration, a who is heavily indebted, and against whom suits for the recovery of debts are going to be filed, sells his house to B to save it from being attached and sold in payment of the debt. If B knows of his fraudulent intention, the sale to B is liable to be set aside at the option of the creditors. It will be seen that the rights of a transferee in good faith and for consideration are not affected even though the transfer is made with intent to defeat the creditor. The second part of the section lays down that every transfer of a movable property made without consideration with intent to defraud a subsequent transferee shall be voidable at the option of such transferee, but no presumption to defraud shall necessarily arise by reason only that a subsequent transfer for consideration was made. It may be noted that Section 53 is applicable only where there is a fraudulent backward transfer of property. If the transaction is not a backward transfer, within the meaning of Section 5 of the This Act, Section 53 cannot be made applicable. This section is not applicable where a deed of dissolution of partnership had the effect of defeating the interest of the creditors. See Ishwar Das Hemraj vs Radha Mal Arjan Das, 1960, Punj, 417. Q. 29. What is the purpose and scope of doctrine of part performance? Ans. Doctrine of backward part performance has been provided in Section 53A of TP Act, in following words. Where any person contracts to transfer for consideration any immovable property by writing signed by him or on his behalf from which the terms necessary to constitute the transfer can be ascertained with reasonable certainty, and the transferee has, in part performance of the contract, taken possession of the property or any part thereof, or the transferee, being already in possession, continues in possession in part performance of the contract and has done some act in furtherance of the contract, and the transferee has performed or is willing to perform his part of the contract. Then, notwithstanding that the contract, though required to be registered, has not been registered, or, where there is an instrument of transfer, that the transfer has not been completed in the manner prescribed therefore by the law for the time being in force. The transferor or any person claiming under him shall be debarred from enforcing against the transferee in persons claiming under him any right in respect of the property of which the transferee has taken or continued in possession, other than a right expressly provided by the terms of the contract, provided that nothing in this section shall affect the rights of a transferee for consideration who has no notice of the contract or of the part performance thereof. The doctrine of part performance is provided in Section 53A, form part of substantive law. After the introduction of Section 53A by Amending Act of 1929 in India, the right to retain possession on the ground of part performance does not depend on equity but rests on the express provisions of the section itself. Section 53A was inserted principally for the protection of ignorant transferees who take possession or spend money in improvements relying on documents which are ineffective as transfers or on contracts which cannot be proved for want of registration. The effect of Section 53A is to relax the strict provisions of this Act and the Registration Act in favor of transferees in order to allow the defense of part performance to be established. In Natulal vs. Phul Chand, Air 1969 South Carolina 546, Supreme Court observed that following conditions are to be fulfilled for making out the defense of part performance. A. That the transferor has contracted to transfer for consideration any immovable property by writing signed by him or on his behalf from which the terms necessary to constitute the transfer can be ascertained with reasonable certainty. B. That the transferee has, in part performance of the contract, taken possession of property or any part thereof, or the transferee, being already in possession, continues in possession in part performance of the contract. C. That the transferee has done some act in furtherance of the contract, and D. That the transferee has performed or is willing to perform his part of the contract. It was then held, if these conditions are fulfilled, then notwithstanding that the contract, though required to be registered, has not been registered, or where there is an instrument of transfer, that the transfer has not been completed in the manner prescribed therefore by the law for the time being in force. Transferor or any person claiming under him is debarred from enforcing against the transferee any right in respect of the property of which the transferee has taken or continued in possession, other than a right expressly provided by the terms of the contract. In Sardar Govindrao Mahadik vs. Devi Sahai, Air 1982 South Carolina 989, it was reiterated by Supreme Court that to qualify for protection on the doctrine of part performance, it must be shown that there is an agreement to transfer of immovable property for consideration, and the contract is evidenced by a writing signed by the person sought to be bound by it, and from which the terms necessary to constitute the transfer can be ascertained with reasonable certainty. Similarly, recently Supreme Court in Mool Chand Bhakru vs. Rohan and others, Air 2002 South Carolina 812, has observed that a person, claiming to be proposed vendee, cannot protect his possession of immovable property on the plea of part performance U.S. 53A. on the basis of an oral agreement the terms of which have not been reduced in writing. Q. 30 define sale and discuss the rights and liabilities of buyer and seller. Uns. Sale defined. Section 54 defines sale as follows. Sale is transfer of ownership in exchange for a price paid, a promised or part paid and part promised. The phrase, transfer of ownership, is significant as signifying that in a sale there is an absolute transfer of all the rights in the property sold. The expression, transfer of ownership, stands in contrast with the expression transfer of an interest, occurring in section 53 in the definition of mortgage and with transfer of a right to injure property, in the definition of lease. Essential elements of a sale. The elements of a sale are: 1. The parties. The parties to a sale are the seller, also called vendor, and buyer, vendee. The seller must be competent to transfer and the buyer may be any person who is not disqualified to be a transferee. 2. Subject matter. The subject matter of a sale is a movable property. A movable property includes 1. Land, 2. Benefits to arise out of land, and 3. Things attached to the earth. In other words, a movable property includes both tangible movable property such as houses, land, and things attached to the earth or intangible movable property such as benefits derived from land, e.g., right of ferry or fishery or a right to a mortgage debt. 3. Conveyance. The sale does not become complete unless the seller actually does an act having an effect in law of transferring the seller's rights in the property to the buyer. In case of tangible movable property of the value of 100 rupees and upwards, or in the case of intangible movable property, the transfer must be effected by a registered instrument. In the case of tangible movable property, of a value less than 100 rupees, the transfer may be made either by registered instrument or by delivery of the property. Delivery of a tangible movable property takes place when the seller places the buyer or such person as he directs, in possession of the property. 4. Price. The consideration of a contract of sale. Price means money price. If consideration of transfer is something other than money, it is not a sale. Of IT vs. M.S. Motors and General Stores Private Limited, Air 1968 South Carolina 200. But prepayment of the price is not a condition precedent to the completion of the sale. If the intention is that the ownership should pass on registration of sale deed, sale is complete as soon as deed is registered or not, whether price is agreed to be paid in part later or not. Buyer can sue for possession. Rights and liabilities of buyer and seller. Section 55 of TP Act 1882 provides for rights and liabilities of buyer and seller as follows. In the absence of a contract to the contrary, the buyer and seller of a movable property respectively are subject to the liabilities and have rights mentioned in rules next following such of them as are applicable to the property sold. 1. The seller is bound to disclose to the buyer any material defect in the property or in the seller's title thereto of which the seller is, and the buyer is not, aware, and which the buyer could not with ordinary care discover. B. To produce to the buyer on his request for examination all documents of title relating to the property which are in the seller's possession or power. C. To answer to the best of his information all relevant questions put to him by the buyer in respect to the property or the title thereto. D. On payment or tender of the amount due in respect of the price, to execute a proper conveyance of the property when the buyer tenders it to him for execution at a proper time and place. A. Between the date of the contract of sale and the delivery of the property. To take as much care of the property and all documents of title relating thereto which are in his possession as an owner of ordinary prudence would take of such property and documents. F. To give, on being so required, the buyer, or such person as he directs, such possession of the property as its nature admits. G. To pay all public charges and rent accrued due in respect of the property up to the date of the sale, the interest on all encumbrances on such property due on such date. And except where the property is sold subject to encumbrances to this charge all encumbrances on the property then existing. 2. The seller shall be deemed to contract with the buyer that the interest which the seller professes to transfer to the buyer subsists, and that he has power to transfer the same. Provided that where the sale is made by a person in a fiduciary character, he shall be deemed to contract with the buyer that the seller has done no act whereby the property is encumbered or whereby he is hindered from transferring it. The benefit of the contract, mentioned in this rule shall be annexed to and shall go with the interest of the transferee is such, and may be enforced by every person in whom that interest is for the whole or any part thereof from time to time vested. 3. Where the whole of the purchase money has been paid to the seller, he is also bound to deliver to the buyer all documents of title relating to the property which are in the seller's possession or power. Provided that, a. Where the seller retains any part of the property comprised in such documents, he is entitled to retain them all, and b. Where the whole of such property is sold to different buyers, the buyer of the lot of greatest value is entitled to such documents. But in case a. The seller, and in case b. The buyer of the lot of the greatest value, is bound upon every reasonable request by the buyer or by any of the other buyers, as the case may be, and at the cost of the person making the request to produce the said documents and furnish such true copies thereof or extracts therefrom as he may require, and in the meantime, the seller or the buyer of the lot of greatest value as the case may be, shall keep the said documents safe, uncancelled and undefaced, unless prevented from so doing by fire or other inevitable accident. 4. The seller is entitled a. To the rents and profits of the property till the ownership thereof passes to the buyer. b. Where the ownership of the property has passed to the buyer before payment of the whole of the purchase money, to a charge, upon the property in the hands of buyer and transferee without consideration or any transferee with notice of the non-payment, for the amount of purchase money or any part thereof remaining unpaid and for interest of such amount or part from the date on which possession has been delivered. 5. The buyer is bound a. to disclose to the seller any fact as to the nature or extent of the seller's interest in the property of which the buyer is aware, but of which he has reason to believe that the seller is not aware, and which materially increases the value of such interest. B. To pay or tender, at the time and place of completing sale, the purchase money to the seller of such person as he directs, provided that, where the property is sold free from encumbrances, the buyer may retain out of the purchase money the amount of any encumbrances on the property existing at the date of the sale, and shall pay the amount so retained to the persons entitled thereto. C. Where the ownership of the property has passed to the buyer, to bear any loss arising from the destruction, injury or decrease in value of the property not caused by the seller. D. Where the ownership of the property has passed to the buyer, as between himself and the seller, to pay all public charges and rent which may become payable in respect of the property, the principal monies due on any encumbrances subject to which the property is sold, and the interest thereon afterwards accruing due. 6. The buyer is entitled a. Where the ownership of the property has passed to him, to the benefit of any improvement or increase in value of the property and to the rents and profits thereof. B. Unless he has improperly declined to accept delivery of the property, to a charge on the property as against the seller and all persons claiming under him, to the extent of the seller's interest in the property, for the amount of any purchase money properly paid by the buyer in anticipation of the delivery and for interest on such amount, and when he properly declines to accept the delivery also for the earnest, if any, and for the costs, if any, awarded to him of a suit to compel specific performance of the contract or to obtain a decree for its rescission, and omission to make such disclosures as are mentioned in this section, paragraph 1, clause a, and paragraph 5, clause a, is fraudulent. In the absence of a contract to contrary, the section sets for the rights and liabilities of the buyer and the seller. There is a clear distinction between the rights and liabilities before the completion of sale and rights and liabilities after the sale. The former are contractual. The latter are regulated by the rule that property having been passed to the buyer, the transaction cannot be avoided. They are as follows. Liabilities of the seller before completion of the sale. The duties of the seller before completion of the sale are a. To disclose material defects in the property or in the seller's title thereto, Section 55, 1, a. B. To produce title deeds, Section 55, 1, b. C. To answer questions as to title, Section 55, 1, c. D. To execute conveyance, Section 55, 1, d. A. To take care of the property, Section 55, 1, 3, and F. To pay outgoings, Section 55, 1, g. Liabilities of seller after completion. Liabilities of seller after completion of sale are a. To hand over the possession, Section 55, 1, f. B. To covenant to title impliedly, Section 55, 2. C. To deliver title deeds on receipt of price, Section 55, 3. Buyer's liabilities before completion. Buyer has following liabilities before completion of sale. I. To disclose facts materially increasing the value of property. Section 55. A. E. To pay price for the property. Buyer has following liabilities after sale. A. To bear loss to property. B. To pay outgoings. Q. 31. A. Define mortgage. What are the essentials of mortgage? Distinguishable it from sale of a movable property. B. Distinguish mortgage and charge. Uns. A. Mortgage. Definition. Section 58 of the TP Act defines mortgage as the transfer of an interest in specific movable property for the purpose of securing the payment of money advance, or to be advanced by way of loan, an existing or future debt, or performance of an engagement which may give rise to a pecuniary liability. The transferor is called a mortgagor, the transferee a mortgagee, the principal money and interest of which payment is secured for the time being are called the mortgage money, and instrument, if any, by which the transfer is effected is called a mortgage deed. The essential elements of a mortgage are the following. I. Mortgage is a transfer of an interest in a movable property. To constitute a mortgage, the transaction should involve the transfer of an interest in a movable property. Unless some interest in property is transferred, there can be no mortgage. Mortgage creates a right in rem. E. The interest transferred should be an interest in specific movable property. A mortgage is valid only when the subject matter of the mortgage is specified with distinctness, otherwise it would be void for vagueness. The description is sufficiently specific if it renders the property identifiable or capable of being ascertained. E. The transfer should be by way of security for an existing or future debt or monetary liability. Where a transfer of an immovable property involves these three elements, the transaction amounts to a mortgage. It is to be made clear that any oral mortgage regarding the immovable property is void. Difference between sale and mortgage. Sale is transfer of ownership. In sale there is an absolute transfer of all rights in the property sold. But in a mortgage there is transfer of an interest. There is a partial transfer. Where a joint family property is subject to mortgage, there is no transfer of ownership, and the co-partners, being its lawful owners, are competent to allot the mortgaged property in oral partition to any of the co-partners. The co-partner to whom the mortgaged property is allotted becomes its absolute owner and is entitled to redeem the mortgage. Consequently, where the right to redeem is transferred by the co-partner, the transferee is also entitled to redeem the mortgage. B. Distinction between mortgage and charge. Charge has been defined in Section 100, TP Act as follows. Where a movable property of one person is by act of parties or operation of law made security for the payment of money to another, and the transaction does not amount to a mortgage, the latter person is said to have a charge on the property. Two kinds of charges. There are two kinds of charges, viz. I. Arising by operation of law. E. Created by the act of parties. A charge resembles a mortgage. It is also a form of security for the payment of money. However, there are following points of difference between a mortgage and a charge. 1. A mortgage is a security for the payment of a debt, while a charge is a security for the payment of the money. Such money may or may not be a debt. There may be a covenant to pay in a mortgage but not so in a charge. 2. A mortgage may be a security for the performance of an engagement that may give rise to a pecuniary liability, but that is not the case with a charge. 3. A charge does not operate to transfer to the charge holder any interest in specific immovable property as a mortgage does. It merely gives the charge holder the right to have a claim satisfied out of a particular property without transferring the property to him. It is only a decree for sale that an interest in the property is transferred in the case of a charge. 4. A charge does not involve a transfer of an interest in specific immovable property, whereas a mortgage does. 5. A mortgage must be executed in respect of a specified property, but a charge may be created upon the wealth or property of a person which is not specified. 6. A mortgage can only be made by act of parties, whereas a charge may arise either by act of parties or by operation of law. 7. A mortgage gives rise to a right in rem, but a charge does not create any such right. The charge is available only against a particular set of persons, i.e. the persons who are affected with notice of the charge. 8. In a charge there lies no personal liability. This is the principal test that distinguishes a charge from a simple mortgage. A mortgagee can follow his security in whosoever hands it goes, whereas a charge holder cannot do so. 9. Defense of purchase for value without notice is not available against a mortgage, whereas it is good defense against a charge. Q. 32. Discuss about different kinds of mortgage. Uns. Kinds of mortgage. As it is provided U.S. 58, A, of TP Act that mortgage is transfer of interest in a specific immovable property for the purpose of securing the payments of money or advance or to be advanced by way of loan, an existing or future debt, or the performance of an engagement which may give rise to a pecuniary liability. Such transfer of interest in immovable property may be in different ways, and thus there are different kinds of mortgage. Section 58, B, to G, of TP Act provide as to different kinds of mortgages, which are as follows. 1. Simple mortgage. Section 58, B, of TP Act says, where, without delivering possession of the mortgaged property, the mortgagor binds himself personally to pay mortgage money, and agrees, expressly or impliedly, that, in the event of his failing to pay according to his contract, the mortgagee shall have right to cause the mortgaged property to be sold and the proceeds of sale to be applied, so far as may be necessary, in payment of the mortgage money. The transaction is called a simple mortgage and the mortgagee a simple mortgagee. So as per section 58, B, following are main elements of simple mortgage. A. Personal undertaking by mortgagor. B. Right to have the mortgaged property sold to mortgagee. C. No delivery of possession. 2. Mortgage by conditional sale. Section 58, C, of TP Act defines mortgage by conditional sale as where The mortgagor ostensibly sells the mortgaged property, on condition that on default of payment of the mortgage money on a certain date the sale shall become absolute, or on condition that on such payment being made the sale shall become void, or on condition that on such payment being made the buyer shall transfer the property to the seller. The transaction is called mortgage by conditional sale and the mortgagee a mortgagee by conditional sale, provided that no such transaction shall be deemed to be a mortgage, unless the condition is embodied in the document which affects or purports to affect the sale. In Tamboli Ramanlal Motilal vs Gharchi Chiman Lal Keshavlal, Hair 1992 South Carolina 1236. It was observed that if there is no relation of debtor and creditor the question of it being mortgage by conditional sale does not arise. Essentials of a mortgage by conditional sale. Following are the essentials of a mortgage by conditional sale. 1. The mortgagor must ostensibly sell the immovable property. 2. There must be a condition that either a. On the repayment of the money due under the mortgage on a certain date, the sale shall become void or the buyer shall retransfer the property to the seller, or b. In default of payment on that date the sale shall become absolute. 3. The condition must be embodied in the document which affects or purports to affect the sale. The word ostensible means that it has an appearance of sale but is really not a sale. It need not be accompanied with possession. It is to be noted that the sale does not become absolute in default of payment on the due date by itself. There must be a decree of foreclosure absolutely depriving the right of redemption of the mortgagor. Deed making reference to loan received in cash and providing that on payment back of loaned amount by executant on or before the due date the creditor would reconvey property to the executant. Held that the document was mortgage by conditional sale. SMT. Janki and Moth. Version Ganesh. Air 1984 All. 219. 3. Usufructuary mortgage. Section 58, d, of TP Act defines usufructuary mortgage, as follows. Where the mortgagor delivers possession or expressly or by implication binds himself to deliver possession of the mortgaged property to the mortgagee, and authorizes him to retain such possession until payment of the mortgage money, and to receive the rents and profits accruing from the property or any part of such rents and profits and to appropriate the same in lieu of interest or in payment of the mortgage money, or partly in lieu of interest or partly in payment of the mortgage money. The transaction is called an usufructuary mortgage and the mortgagee an usufructuary mortgagee. A usufructuary mortgage is one in which I. Delivery of possession, or an express or implied undertaking on the part of the mortgagor to deliver it, and e. the enjoyment of the usufruct by the mortgagee until all his dues under the mortgage are paid off. It follows, therefore, that the mortgagee has neither the personal covenant of the mortgage to pay the mortgage money nor a right of sale nor a right to foreclose the mortgage. His only remedy is to pay himself out of the rents and profits of the mortgaged property. In this form of mortgage the property is given as a security to the mortgagee who is let into possession or is promised to be let into possession of the property and is permitted to repay himself out. of the rents and profits of such property or out of a portion thereof. One great disadvantage of this form of mortgage is that the mortgagee is under an obligation to exercise great care and caution in the management of the property, and he is to account for his receipts of the usufruct of the property. Another disadvantage is that it involves the locking up of one's money, because the usufruct of the property may not be sufficient to repay any part of the principal after payment of interest. Possession. Essence of usufructuary mortgage is that mortgagor either expressly or by necessary implication put the mortgagee in possession of property of mortgagor. In Hathika vs. Puttiya Parail Padmanathan, Hair 1994 Ka. 141, the mortgagor had borrowed 1,000 rupees per from mortgagee, and the possession of building remained with mortgagor. Mortgaged money was to be repaid within a period of 6 months, and in case of default the mortgagee had the right to bring the property to sale and realize the amount. The document, which was described as usufructuary mortgage, was held to be anomalous mortgage and not usufructuary mortgage, as it had character of a simple mortgage too, as mortgage was given right to sell pay property to realize the mortgaged amount. So in usufructuary mortgage, mortgagor is bound to put the mortgagee in possession of property, and if the possession is not delivered, the mortgagee may sue for possession or for recovery of mortgaged money. U.S. 68 D. of TP Act. Rents and profits. The method by which the rents and profits are to be appropriated depends upon the terms of the mortgage deed. The rents and profits or part of the rents and profits may be appropriated: 1. In lieu of interest, 2. In lieu of principal, or 3. In lieu of principal and interest. In the first case, the mortgagor recovers possession when he pays the principal. In the second case, the mortgagor continues to pay interest and is entitled to recover possession when the rents and profits received by the mortgagee equal the amount of the principal. In the last case, the mortgagor is not to recover possession until the principal and interest are paid out of the rents and profits. No personal liability. The mortgagor cannot be sued personally for the debt. The mortgagee is only entitled to remain in possession of the mortgaged property till the principal and interest are defrayed according to the terms of the agreement. Atmaram vs. Suryan, 1928 La. 355. Since a usufructuary mortgagee is entitled to remain in possession until the debt is paid off, no time limit can be fixed expressly during which the mortgage is to subsist. Ramnarayan Singh vs. Adhindra Nath, 44 IA 87. Zuri-Peshgi leases. Zuri-Peshgi leases bear a close resemblance to usufructuary mortgages. A Zuri-Peshgi lease means a lease for a lump sum paid in advance. The differences between a Zuri-Peshgi lease and usufructuary mortgage are: 1. Under a usufructuary mortgage, the mortgagee is authorized to retain possession until the mortgage money is satisfied, while in a Zuri-Peshgi lease, the lessee is entitled to remain in possession for a definite period of time. 2. In a Zuri-Peshgi lease, the relationship of debtor and creditor does not subsist. 3. Sometimes, there are usufructuary mortgages in which there is no change of possession. The mortgagee executing a lease in favor of the mortgagor who retains possession and agrees to pay rent, which is generally equivalent to the interest of the amount lent or due. Whereas in case of a zuri peshgi lease, the lessee takes physical possession of the property leased. Kanam kuzikanam and usufructuary mortgage. A kanam kuzikanam and a usufructuary mortgage have many common features. Both the transactions involve or may involve transfer of possession on payment of money by the transferee, set-off of profits against interest and retention of possession until repayment of the money. In spite of their close resemblance, the essential distinction between the two types of transactions must not be overlooked. A kanam kuzikanam is a lease and, therefore, a transfer of a right to enjoy the property. A mortgage is a transfer of an interest in the property for securing the repayment of a debt. The purpose of one is to enable enjoyment of the property by the transferee while that of the other is to secure the debt. Where a mortgage is created by a landowner, he transfers an interest in the land concerned. In case the mortgage is with possession, then the landowner not only transfers an interest in the immovable property, but also transfers possession thereof. Obviously, when this mortgage is redeemed, the mortgagor must necessarily take back the interest which he had earlier transferred, and this would amount to retransfer to him. So that acquisition by him would be a transfer to him. Labh Singh vs Punjab State 1971, 73 PLR 765. 4. English mortgage. Where the mortgagor binds himself to repay the mortgage money on a certain date, and transfers the mortgaged property absolutely to the mortgagee but subject to the proviso that he will retransfer it to the mortgagor upon payment of the mortgage money as agreed. The transaction is called an English mortgage. This form of mortgage is said to be mostly confined to presidency towns of Calcutta, Bombay and Madras. In this form, possession is given to the mortgagee. In the case of Kartik Chandra Mullik vs Parshottam Das Goel, Air 1988 Cal. 247. It was held that if there is an absolute transfer of undivided shares in suit property by mortgagor to mortgagee subject to provision for transfer and right of mortgagee to redeem mortgaged transaction is an English mortgage. In this form of mortgage, the mortgagee has right to apply for passing decree for sale of the mortgage property. Kartik Chandra Mullik vs Parshottam Das Goel, AIR 1988 Cal. 247. 5. Mortgage by deposit of title deeds. Mortgage by deposit of title deeds has been defined in Section 58, F, of TP Act as where a person in any of the following towns, namely, the towns of Calcutta, Madras, and Bombay, and in any other town which the state government concerned may, by notification in the official gazette, specify in this behalf, delivers to a creditor or his agent documents of title to a movable property, with intent to create a security thereon. The transaction is called a mortgage by deposit of title deeds. Mortgage by deposit of title deed is also known as equitable mortgage. The two ingredients of an equitable mortgage are I. Delivery of the title deeds of the creditor or his agent, e. An intention to create a security on them. Delivery, means delivery of actual possession as a result of the agreement. Deposit of registration copy of gift deed showing title of mortgagor was sufficient to create a valid equitable mortgage. Similarly, where the original title deed is lost, a certified copy of the document may be deposited provided the original deed is proved to be actually lost. Ishwar Das vs. Dhanang Singh, AIR 1985 Del. 83. The object of the legislature in providing for this kind of mortgage is to give facility to the mercantile community in cases where it may be necessary to raise money forthwith before an opportunity can be afforded of preparing the mortgage deed. The essential requisites of such a mortgage may be described as under: 1. There must be a debt. 2. Deposit of title deeds, and 3. An intention that the deeds shall be security for the debt. The first thing required is a debt. It may be an existing or a future debt. The title deeds may be deposited also to cover a general balance that may be found on a running account. The second element is that the debtor should deliver the documents of title to a movable property on which the security is intended to be created to the creditor or his agent. It is however not necessary that the property to which the documents relate should situate within one of the towns mentioned in the clause. It is enough if the title deeds of the property situating at any place are handed over to the creditor in town specified in the Act. The property may situate outside the town mentioned in the clause. Physical delivery of documents by the debtor to the creditor is not the only mode of deposit. There may be a constructive deposit. If the creditor is already in possession of the documents of the property of the debtor, then only thing to be seen is whether the parties agreed to treat the documents in the possession of the creditor as delivery of the deed to him for the purpose of the transaction. The third element is that the deposit of the title deeds must be made with a distinct intention of the creating a security for the debt. The mere fact that the title deeds have been deposited is not sufficient unless there is an agreement that the deeds should stand as security. There is no presumption of law that the mere deposit of title deeds constitute a mortgage. No such presumption has been laid down either in the Evidence Act or in the Transfer of Property Act. It may be noted that though a mortgage by deposit of title deeds can be created by mere deposit of title deeds without any written contract between the parties, on the contract or the bargain between the parties is reduced to writing, it cannot become effective unless the writing is registered. But registration is not necessary if the mortgage is complete without writing and the writing is merely a statement that the mortgage has been effected. Section 96 of the Transfer of Property Act places mortgages by deposit of title deeds on the same footing as simple mortgages. In Bank of Rajasthan Limited vs. Pala Ram Gupta, Air 2001 Del. 58, it was observed that when defendant seeking loan for construction of building from plaintiff bank and defendant depositing original title deed for said purpose with plaintiff bank, it amounts to creation of equitable mortgage. 6. Anomalous mortgage. Section 58 Grams TP Act lays down that a mortgage which is not a simple mortgage, a mortgage by conditional sale, and usufructuary mortgage An English mortgage or a mortgage by deposit of title deeds within the meaning of this section is called an anomalous mortgage. Out of 6 classes of mortgages is described in clauses B to G of Section 58. TP Act. First 5 are specific classes of mortgages and sixth one, i.e. anomalous mortgage, is a residuary clause of mortgage, which simply means that if there is a mortgage of any type other than those specified in clauses B to F of Section 58 TP Act, then that falls under residuary clause, i.e. Section 58 grams, and is known as anomalous mortgage. If a mortgage is neither purely simple nor usufructuary exclusively but mixture of two, such mortgage is anomalous mortgage. The classification of mortgages given in Section 58 TP Act is not exhaustive. It only describes certain forms of mortgages which are in common use in India. Several other kinds of mortgages are also in use in various parts of India which have been given the name of anomalous mortgage. It has been defined in the Act as a mortgage which does not fall under any of the 5 specific clauses. An anomalous mortgage includes 1. A simple mortgage usufructuary and 2. A mortgage usufructuary by conditional sale. Modes of transfer in mortgage. Section 59 TP Act provides that where the principal money secured is 100 rupees or upwards, a mortgage, other than a mortgage by deposit of title deeds, can be effected only by a registered instrument signed by the mortgagor and attested by at least 2 witnesses. Where the principal money secured is less than 100 rupees, a mortgage may be effected either by a registered instrument signed and attested as aforesaid or, except in the case of a simple mortgage, by delivery of the property. Thus, as per Section 59, there are 3 ways in which property may be transferred by way of mortgage. 1. By registered instrument, when mortgage is for 100 rupees, or more and it is not by deposit of title deeds.